Good afternoon. Today is February 6, 2024, and welcome to the bill hearings for the Ways and Means Committee. First, I want to remind committee members at the top of our hearing and not at the end, because I might forget, tomorrow, 2:30 hearings in this room because we have the state of the state, so I'm going to allow you all to get some lunch. 2:30 will start tomorrow at 2:30 and not 1 o'clock. I'll say it on the floor, but just letting you know now because you'll hear me now and maybe not tomorrow. So see you all tomorrow at 2:30. Calling our first bill, House Bill 434, and that would be Chair Atterbury's bill. And I'm just going to sit right here because it's going to be super quick and it's an amazing bill and you're going to support it. So I am here to ask for a favorable report on House Bill 434. So currently, I just said this is a simple bill. Currently, 501c3s are prohibited from making political contributions. However, they are required to file a report of contributions. So that would be a report of 0 contributions with the State Board of Elections. If they fail to do that, then they will incur a $1,000 penalty fee. So this is something that was passed, I believe, by accident in 2022. And so it's just going back to correct it. It is not changing the requirement that 501c3s have to register with the State Ethics Commission for various reasons, including if they hire a lobbyist to lobby on their behalf, then they will have to go ahead, excuse me, and report. And with that, I will conclude my testimony and ask Ms. Jordan to catch her breath and come on up. Thank you very much. Whenever you're ready.
Thank you so much, Madam Chair. I was in Judiciary where I live, and it's always a pleasure to visit Ways and Means. I'm Lisa Jordan. I'm the Executive Director of the Maryland Coalition Against Sexual Assault. We are here in strong support of House Bill 434, which you've already heard about. I am here in an effort to be efficient and representing nonprofits all across the state. Nonprofits that are 501c3s are forbidden from ever contributing to any of your campaigns. Many of you know this because you've called and tried, and I've said, no, we can't do that. So it was a huge surprise to the nonprofit community to find out that we were supposed to be filing reports with the Board of Elections. This concerned all of us, partly because many of us had no idea we had to file the reports. I didn't know until I got the $1,000 bill saying, hey, you didn't file a report. And many of my colleagues, when I told them about this bill, they were like, what are you talking about? We should not even talk to the Board of Elections. The IRS will get suspicious if we are talking to the Board of Elections. And so I am so grateful to your chair for introducing this bill to correct what I can only assume was an oversight to include us in the group of people that have to file a report with the Board of Elections about political contributions that we are 100% forbidden from ever making. They are 0 reports. There'll always be 0 reports. If there was actually a concern about nefarious conduct, you know, one of us is violating things, you can still figure that out by looking at 990s, by looking at our lobbyist ethics reports. There's no bar on investigation. So for those reasons, the Maryland Coalition Against Sexual Assault, together with our colleagues at MANO, the Women's Law Center, and other nonprofit 501c3 charities, begs you and urges a favorable report on House Bill 434.
Thank you, Ms. Jordan. Questions? We'll start with Delegate Hartman, and I'm going to ask Mr. Ward to answer any questions you might have for me.
Sure. Thank you, Madam Chair, and thank you. So the people that were fined, were the fines mitigated, or is this bill retroactive that would allow them to be reimbursed for their fines?
So the bills have not yet been mitigated. I actually had hoped that they would be by the time we got to this hearing. Most of us have requested that they be waived. And my understanding from Mr. Damaris, who I believe is somewhere in Annapolis, was that that was still being presented to the board. Certainly if that is not correct and they have not waived the fines, perhaps the committee would consider uncodified language or something to waive the fines. I do think that many people don't even know that they have the fines.
So if we made this retroactive, could this be made retroactive to do a fix one? You know, this is like, sounds like government at its finest. And, you know, is there a way we can fix both problems with the one bill? You said Stan was going to answer, so. Okay. Thank you.
Any other questions from the committee? Okay, seeing none. Thank you very much, Ms. Jordan.
Thank you, Madam Chair.
Have fun in that other committee.
Yes, I will do my best.
That concludes the testimony on House Bill 434. House Bill 423 is a Montgomery County delegation bill, and Delegate Kaufman, welcome, is presenting.
Thank you, Madam
Oh,
Chair.
I'm sorry, can I just interrupt you 1 second? I just want the committee to know, if you don't already know, that our colleague used to work in the Ways and Means Committee, which predates, I think, anybody who's except Mr. Ward.
Except
He was here. Right. So welcome to Ways and Means.
It's good to be back home. I have so many wonderful memories. And I am forever grateful to Chair Hickson of blessed memory and to Stan for giving me my very first job as a young 25-year-old. It's just good to be back home, and it's interesting how many fewer questions you all ask than in my committee. I'm here to but it's great to be back home. Good afternoon, Chair Atterbury and Vice Chair Wilkins, members of the Ways and Means Committee. My name is Delegate Aaron Kaufman, representing District 18 in Montgomery County. However, today I'm speaking about HB 423 on behalf of the whole Montgomery County delegation, which passed this bill unanimously early in session. I want to thank Delegate Julie Plakovich-Carr for taking the lead on this issue for several years and passing the baton on to me to take the charge. You're very familiar with this local bill because the Montgomery County House delegation unanimously passed it, prior versions of this bill in 2022, in addition to earlier this year in 2022, 2021, and 2019. This time, the bill has the support of the Montgomery County Executive and the Montgomery County Council. Ranked choice voting also, very importantly, has the support of Senate President Bill Ferguson, who was quoted in an article in October in Maryland Matters as saying, "I'm almost certain that ranked choice voting is the way to go, but more education is needed." So today I will be providing that education. Ranked choice voting, or RCV, is a method of voting in which voters rank candidates by preference on their ballots. This method of voting ensures a fair and more representative outcome by considering a voter's preference beyond their first choice candidate and allows voters to rank candidates from their favorite to their least favorite, thus showing their true preferences, although they love us all, of course. Ranked choice voting also ensures that candidates nominated within each party have a majority consensus. This method of voting also encourages a more diverse pool of candidates to run within existing parties, including candidates of color. Ranked choice voting is already used in a variety of states and localities, both red and blue. Alaska and Maine use ranked choice voting in federal and statewide elections. 14 states use ranked choice voting in certain localities, which is what the Montgomery County delegation is asking for. This year, the state of Nevada will have a measure on its ballot that, if it passes, it will allow for RCV for state and congressional elections, congressional races. Oregon will also have a measure on the ballot that will allow RCV for all state and federal elections. Ranked choice voting has the potential of encouraging more civil campaigns and less divisive political discourse And ideally, it will take the toxicity out of politics. I'm an optimist. Ranked choice voting is catching on in many states and municipalities, and it can open the door for future election reforms that will enhance the levels of democracy. I ask for a favorable report on this legislation and for the principle of local courtesy on 423 to be honored. We're really looking forward to working with the committee on any questions or concerns so that this bill can be passed. Again, it's good to be back home. I have to go to that committee where Ms. Jordan lives, but I'll gladly take any questions.
Thank you. Questions, Delegate Young, then Delegate Fair.
Thank you, Madam Chair, and thank you, Delegate Kaufman. Just as a previous member of your committee, it is certainly a lot less questions over here, my good sir. What I wanted to quickly just ask, if you could repeat real quickly, those states that are already using it and the ones that are about to use it. I just missed it when you said it the first
Oh,
time.
sure.
Thank you.
And I just want to also say that it's it is enabling legislation. So it's the choice of the county whether or not they want to do this. This is just us giving them the option. Ranked choice voting is already used in a variety of states and localities. Alaska and Maine use it for state and federal elections. And so you have a red and a blue state there. And Oregon and Nevada will have, Delegate Young, referendums on their ballots about whether or not to use it in state and federal elections. And numerous localities have it as well.
Delegate Fair, then Delegate Hornberger.
Thank you so much, Madam Chair, and good to see my good friend from Montgomery County. How are you?
Good, thank you. How are you?
Good. It's just a question about the process by how you all came to ranked choice voting. This is obviously a discussion that's happening all over the country, but they're talking about not just ranked choice voting, but also range voting, approval voting, that the Condorcet voting. And so I was just curious, did Montgomery County delegation consider all those? I know that the bill only calls out ranked choice voting as the only enabling option.
Well, Mr. Ward actually wrote the bill, God bless him. And I think it also refers to approval voting, but that predated me because I've only been here a year and this bill keeps being presented and Delegate Plakovich-Carr bequeathed it to me. But I think that well before I got here that the Montgomery County delegation just decided that this was the way to go.
This was perfect. Thank you so much. Just curious.
Thank you, Madam Chair. Thank you for bringing this bill forward. I just had a question. So this again is just for the county elected officials?
Yes, people like the Montgomery County Register of Wills, the Montgomery County Sheriff, the Montgomery County Executive, the Montgomery County Council, local offices. So this will not affect the people of Cecil.
Correct. So my concern here is that you're going to have a split ballot because you're running on the gubernatorial cycle. You'll have candidates on there that are not ranked choice alongside ones that are.
Well, what I would say, Delegate, is that if this legislation passes, the Montgomery County Council and the county executive will have to decide whether or not this is the best, it's the way to go. And I'm sure there will be people advocating your point of view.
So, and then my final question, if I may, is the Board of Elections indicated that they're willing to accommodate this split ballot?
I do not recall that the Montgomery County Board of Elections, whether or not they've weighed in or not. So.
Okay. All right. Well, thanks so much.
Any further questions? Delegate Miller.
Just real quick, thank you, Madam Chair. Are the machines set up to be able to do that kind of on Delegate Hornberger's thing?
Well, I think they would be, and I think that the fiscal note speaks to it a bit. But keep in mind, Delegate Miller, that we know that we have the ability to do this because you have a red state like Alaska and a blue state like Maine and numerous other municipalities that have already done this successfully on numerous occasions. So I think that I think that Montgomery County, again, if the county council and the county executive choose to do it, could easily accommodate it. And I'm sure the machines would be part of the discussion, but I think that since it's already done, in other states, I'm sure the Montgomery County Board of Elections could acquire, or maybe already has, equipment that could do this.
Any further questions? Okay, seeing none, thank you very much, Delegate Kaufman.
It's always a pleasure.
And that concludes the testimony on House Bill 423. House Bill 436, Delegate Fair. And I have Ariel Franco, Morgan Drayton, Nashona Kess, and Nikki Tyree. If any of those people are here, do you want to come forward? And then there is one favorable that's virtual, so we'll do that after all are present testify. Some of these folks, I don't know, might be testifying elsewhere. Ariel Franco, Morgan Drayton from Common Cause, Nashona Kess from Maryland NAACP, and Nikki Tyree from the League of Women Voters of Maryland. And then you have Jackie Slade, who is with us virtually, I think.
Yes.
Okay, we'll get you in 1 second, Ms. Slade. Thank you. Whenever you're ready.
Just a second.
Thank you, Chair Atterbury, Vice Chair Wilkins, esteemed members of our favorite committee, the Ways and Means Committee. For the record, I'm Delegate Chris Fair presenting House Bill 436. This bill is a very complicated bill. It seeks to lower the age of pre-registration from 16 years to 15 years and 9 months. Future voters will also be informed at which election they will be allowed to begin voting. Why is this important? Well, there's 2 reasons. First, when young people go out to get their driver's license at 16, they can affirm their desire to register to vote. However, if that future driver gets a learner's permit at 15 years and 9 months, they do not have that opportunity to pre-register, creating a confusing 2-part system. As District 22 resident T. Carter Ross illuminated in his written testimony, quote, current rules limiting pre-registration to those 16 and older creates a disconnect when teenagers can apply for a learner's permit and when they can pre-register to vote. Second, some municipalities allow residents to vote in their municipal elections as early as age 16. This bill will help local election directors reduce same-day voter registration for those voters who turn 16 shortly before or on election day. I urge you to support House Bill 436, which continues Maryland's efforts to empower future generations of voters and guarantees early engagement in our democratic system. I respectfully request a favorable report. Thank you, Madam Chair.
Good afternoon, Chair Atterbury, Vice Chair, and committee members. My name is Ari Franco, and I'm the Youth Engagement Organizer with Common Cause, testifying in support of House Bill 436. Common Cause supports House Bill 436 and the lowering of the minimum pre-registration age from 16 to 15 3/4 years old. Young people already submit the necessary supporting documents to the MVA when they are first eligible to begin the driver's licensing process. This legislation would simply allow them to pre-register to vote at that time, lowering the minimum age requirement from 16 to 15 3/4. Those who pre-register at the new minimum age would still automatically become eligible to vote when they turn 18. This minor change offers young people an earlier opportunity to begin engaging with Maryland's electoral system. Pre-registration increases turnout and engagement with young voters who have historically been the least likely group to vote. This change allows young people to be added to the voter file even sooner, which will in turn increase their engagement and contact with campaigns and electoral information institutions during the election cycles, which will help foster young voter turnout and participation in our democracy. Common Cause urges a favorable report. I would also like to uplift the League of Women Voters' support for this bill, but they're in another committee right now. Thank you.
Thank you. I appreciate that. I do think we have Jacqueline Slade.
Yes.
Okay, let's just get you up on the screen and then you can go for 2 minutes. 1 second. Okay, you can stop the timer. 1 second. Yeah. Okay, whenever you're ready, Ms. Slade, go ahead.
Okay, so I'm Jacqueline Slade, and I'm here representing the League of Women Voters from the Protect the Vote Committee. So the League of Women Voters is a nonpartisan organization, and it has 1,500 members statewide. And we advocate for an election system that is representative and increases voter representation. That's why we support House Bill 436, which aligns the age young voters can register with the age they can receive their learner's permit. This will allow those receiving their learner's permit before 16 to register at that time. This will help increase the representation of younger voters and imbue them with a sense of civic responsibility. Eligible Marylanders ages 18 to 24 have lower rates of registration and voting than any other age group. According to U.S. Census statistics from 2022, only about 55.7% of this cohort in Maryland is registered, and only 23.5% voted. This has gone down since about 2018, when about 60% of this cohort was registered and 38% voted. It's important to sponsor efforts that expand youth participation at every access point. According to Tufts University's Center for Information and Research on Civic Learning and Engagement, 26% of students who didn't recall being encouraged to vote in high school agreed with the statement, voting is a waste of time. The percentage of those who agreed dropped by half to 12% among young people who had been encouraged to vote in high school. The National Voter Registration Act, passed federally in 1993, requires every state to offer voter registration opportunities at motor vehicle agencies. However, this missed students who received a learner's permit in Maryland before the age of 16. Since there's an established precedent through programs such as Motor Voter to encourage voter registration among those who are 16 and above, those who are 15 and 9 months should have the opportunity as well. Therefore, the League of Women Voters urges a favorable report on HB 436.
Thank you very much. Are there any questions for this panel? Yes, Delegate Hornberger.
Thank you. Great bill. Thank you for bringing it forward. The fiscal analysis is silent to party registration. Could you speak a little bit to that?
So when a voter is given the option to register, or when a future voter is given the option to register, they are given the option to affiliate with a party at that time. So it would be silent just because the normal process would be followed where they would just extend it, the already existing option for a 16-year-old to a person with 15 years.
Okay, so it would be the same posture as what's allowed now.
Exactly.
Okay, all right.
Thank you so much.
Any further questions? Okay, thank you all very much. We did have one individual signed up unfavorable, Vince McAvoy, but he is not in the waiting room. So that concludes the testimony on House Bill 436. Calling House Bill 54, that is my bill. I'm going to come up to the table. And I would ask that if any of these folks are here to come up with me, Councilwoman Odette Ramos, William Steinwedel, Susan Jahowski, and Scott Poirier. And Stephen Kappen, and then somebody is here virtually too.
Whenever you're ready, Madam Chair.
Okay. Hello, committee members. This is my first time testifying in front of you all this session. So happy to be here. Where's my round of applause? Thank you. Thank you. Thank you. Love it. Okay, so you all have seen, particularly those of you who have been on this committee longer than I have seen this bill multiple times. But I am here to ask for your favorable report on House Bill 54. And with the help of our wonderful Mr. Ward, I think this bill improves the version that we have seen over the past couple years, and I'll point out the differences. So the bill essentially does three things. It requires the tax sale ombudsman to contract with a vendor to operate a payment plan program for payment of property taxes in advance, in arrears, or that are currently due. So that's a new piece to the legislation. Second, it authorizes counties and municipalities to create installment payment plans for taxes that are in arrears and only on residential properties. And that's new too. So the part that you guys are super funny, I see what's happening here. The part that is new is that, or that is the same, that is you all are familiar with. It provides an exemption for the transfer of residential property from an estate to an heir from requiring that all taxes, assessments, and other fees be paid upfront. And I don't have to tell all of you, but it would permit them to enter into a payment plan to pay those so that we can help the creation of intergenerational wealth, so that we can help individuals that don't have access to a lot of money to get past that barrier for individuals of people of limited means, and so that we can keep homes and families through generations. And so that's why, to me, I think this is an important bill. And with that, I will pass it off to Councilwoman Ramos. Thank you very much.
Thank you, Madam Chair, Madam Vice Chair, members of the committee. My name is Odette Ramos. I am a councilwoman from the 14th District in Baltimore City. We are asking for your favorable report. This is a great bill that we definitely need in Baltimore City and statewide. I'll just talk about my district. One of the reasons why we have many vacant properties in the city is because sometimes once somebody passes, the elder passes, and there may be some taxes or liens on the property, the heir cannot get that property transferred because they have to pay the liens up front. And so this bill would allow that transfer to occur and then a payment plan to be in. And that is going to help us greatly with, again, intergenerational wealth, but also making sure that we're keeping properties from being vacant. And that in my district is about 15% of the vacant properties in my district. So it would make a very big difference for us. And then I believe there's going to be one amendment that'll allow for the Baltimore City Council to create the payment plans for Baltimore City. So thank you very much for your time. And thank you again, Madam Chair, for introducing the bill. Thank you.
Chair Atterbury, members of the committee. My name is Stephen Coppin, and I am an attorney at the Maryland Volunteer Lawyer Service. And I work with clients who are struggling, facing this issue every day. I work with low-income clients who are facing estate administration and property law barriers to justice. HB 54 would allow heirs to inherit property without arbitrary hurdles. It would help low-income Marylanders preserve their hard-fought assets and will allow them to build intergenerational wealth. I urge your support of this common sense bill. First, this bill would have no significant cost to the government. The taxes are not forgiven, and the ultimate enforcement mechanism of tax sale is preserved. Second, requiring low-income heirs to pay the taxes before getting clear title is not equitable. Low-income heirs, like the clients in my project, are not able to access homeowner assistance because they lack clear title. The onerous requirement to prepay a secured debt is what creates this issue. These issues overlap with long-term systemic racial inequality and are prevalent in Black communities across Maryland. By allowing families to leverage their legacies, this legislation will mitigate the wealth gap for Black Marylanders. Third, I will emphasize that barriers to transfer stop families from probating property, which makes the property much more likely to be lost through partition, tax sale, or foreclosure. In closing, I'll tell you about one of my clients. Marcia's home has been in her family for 66 years. She can't get the property into her name until she pays off several $1,000s in property taxes and water bills. In the meantime, she doesn't qualify for home repair grants to help her fix her roof, plumbing, or her electrical issues. In 2023, her home's tax assessed value jumped from $31,000 to $65,000. That means her property taxes will more than double. That wouldn't have happened if she had had the homestead tax credit. Therefore, she will end up paying more in taxes because she already couldn't afford them and that there was an arbitrary legal barrier to clear title. Thank you.
Hello, my name is William Steinwhittle, and I'm the supervising attorney for the Foreclosure Legal Assistance Project, Maryland Legal Aid Bureau, which is the largest nonprofit law firm in the state of Maryland. So the amount of title issues that we see at Maryland Legal Aid is astonishing. I just wanted to tell you, and this bill will have a great effect on preserving generational wealth amongst all low-income communities, minority and otherwise. And I just have two stories I want to tell, one from Baltimore City and one from Howard County. In Baltimore City, I represented a client a couple years ago where her son was the primary breadwinner and paid the property taxes on the property. He was then unfortunately struck by a vehicle and killed. She lost his income and was living on a fixed income of Social Security. But because the property was not in her name, it was in her father's name, she could not get the property taxes in order to save the house. Due to our quick involvement, we were able to stop the property from going to foreclosure. However, this happens more times than we are able to stop it. And this bill would go a long way to making sure that the lack of transparency the lack of transition would not prevent the loss of property. In addition, we once represented a client in Howard County who was being defrauded or was being negligently treated by a representative payee who was paying her her bills, and they were basically not doing that. And she was on the verge of losing a property that was nearly worth $400,000. Had been in her family since the 50s due to a tax sale. If we had been able to immediately transfer this property, as this bill would allow, this situation could have been avoided. So for those reasons, Maryland Legal Aid urges a favorable report on House Bill 54.
Thank you, Chair Atterbury, Vice Chair Wilkins, and members of the committee for this opportunity to testify on House Bill 54. For the record, my name is Scott Boyer. I am the clerk of the Circuit Court for Anne Arundel County, and I also represent today the association representing all of the elected clerks in the state of Maryland who are responsible for recording land records in the state of Maryland. The clerks of the court have reviewed the bill, and we just have two friendly amendments. We've been in contact with Chair Atterbury's office, and we submitted our amendments on paper. The two amendments are very simple. Number one, in one section of the bill, it asks that the clerks of court pass on information on the payment plans. The clerks of the court are downstream from the payment of the taxes. In other words, we do not record the land record transfer until we get the stamp from the county tax office. So we've proposed an amendment where the county tax office, if there's a payment plan, that the county tax office give the information on the payment plan. Because you want the person to get the information on the payment plan before they pay their taxes, not after they pay their taxes. Second amendment is about the documentation that we receive before we record the transfer of the deed. Right now, the county tax office has a stamp, has two stamps. One stamp says that the taxes have been paid in full. Another stamp says that no taxes are due. If there's a payment plan, we think there ought to be a third version, a third variation on the endorsement that comes from the county tax office. We just want to make sure that that documentation is there before we record the deed. So those are the two amendments that we've proposed. And if you have any questions, I'm available. Thank you very much for this opportunity to testify.
Thank you so much to this panel. Madam Chair, we did have one other person that was favorable in person. Is Susan Zuhowiski here? All right, not seeing her. We will go on to questions. Delegate Buckle. Okay, we have someone who's virtual. Whoops.
Welcome to Ways and Means.
Allison Harris, are you there?
I'm here.
Yep. Thank you.
Thank you. Good afternoon. I'm Allison Harris, Director of the Home Preservation Project of the Pro Bono Resource Center of Maryland. And I'm here as a legal services provider of tax sale and other homeownership related services to homeowners in Maryland. I run tax sale prevention clinics each spring for homeowners who are delinquent on their taxes and at risk of tax sale. Each year, approximately 1/4 of my clients do not have title to their home, and almost all of those are heir homeowners with tangled titles. They're the adult children of homeowners who own their homes for decades, paid off the mortgage long ago, and worked hard to gain full equity in the home. When the parents passed away, the adult child inherited the home, but did not go through the expense or steps to get the deed transferred in their name. This is almost always because of the prepayment requirement that forces an unexpected and large expense on the family. They just cannot bear this payment at that time, and it precludes those heirs who would be eligible for homeowners' property tax credits from receiving that discount prior to paying the full bill. The full property tax bill required in a lump sum is simply out of reach for so many families, and they just are not able to get over that hurdle to get the deed in their names. I really do see so many clients facing this hurdle. They get to that last step to record that deed, and they're just unable to make a lump sum payment, so they never manage to record the new deed. This tangled title problem frequently lands families in tax sale. By exempting these surviving family members of the homeowners from the prepayment requirement, if they opt into a payment plan, these heir homeowners would be much better positioned to obtain title, to avoid tax sale foreclosure, and to keep those homes and that equity their families have worked to build. So thank you for the opportunity to testify.
Thank you so much, Delegate Buckle.
You, Madam Vice Chair, I did have one sort of substantive question. We all just did hit our lights obviously before to make sure that Madam Chair knew we had questions. But my question is, what happens? I really like the idea of a payment plan. You know, I've handled a variety of different transactions and situations for people professionally. It doesn't matter your means sometimes. Limited means, middle class means, upper middle class means. Sometimes that tax bill, and you're like, it's $11,000. I don't have 11,000, you know, a lot of people don't have $11,000 just sitting around to pay, but they could pay it off over a year or 2 years or whatever. What happens though under the bill if the people default on the payment plan? So someone comes in and says, yeah, I want to take title to my mom's house that she left me, but I can't pay the taxes. It's $4,000 and I want to pay $300 and some a month for a year. That's what is agreed to. But I really don't have the money. So I make one payment, I get the deed transferred in my name, and then I don't make the payments. And then because the deed's in my name, I then go and sell the property because it's mine now. So month 3 comes along, I've entered into a contract to sell the property, and now they show, well, the taxes weren't paid, but they're not due, they're under a payment plan. What guardrails exist to say that, you know, if you're not in compliance with the payment plan, we have a way to come back and get the taxes or to prevent you from alienating the property further?
I'm going to defer to Stan, Mr.
I
Wheeler.
will shift my gaze
Thank
to my
you.
man Stan. Go ahead, Stan, I can hear you.
Yeah, so the remedies would be the same. The property is still subject to tax sale if it came to that. And there would still be the normal restrictions on transfer with if you've got an outstanding.
So if I'm under a plan and I'm in default of the plan, essentially, everyone will get immediate notice of that so that if I go to sell it, it'll show up in the clerk's office, in the tax office. Normally, when you sell a property, you have to get a stamp, essentially. They used to physically stamp them, now they do it electronically to authorize to the clerk's office that you can sell it. It's clear.
Right.
That's my only fear with this. I think it's a great idea. My fear though is that you'll wind up, the municipalities, the counties, the state to an extent will wind up being like, we don't have, you know, we let that property go, or we're just never going to get paid on it. And now it's out there. So there is a guardrail inherent to do that.
It could probably be made clearer in the bill, but nothing in the bill changes the process you just described about having to have the tax stamp to sell.
So when you enter into the payment plan, you're not clean in terms of the ability to alienate. You still have the tax lien. It's just being paid off over time.
Right. Yeah. And I think if you weren't in compliance with the payment plan, then you would not be able to transfer it. I think that's how it would work, but it's something that could be clarified.
Thank you very much. I appreciate it.
Thank you so much. Seeing no other questions, that ends the bill hearing on House Bill 54.
Thank you.
Thank you. As Madam Chair takes back her seat, why don't we call up the witnesses, the first panel for HB 243. And that will be the secretary's panel, the sponsor panel, which Carmel Rokes, Secretary Day, Michael Higgs. You can begin when you're ready.
Thank you so much. Chair Atterbury, Vice Chair Wilkins, members of the committee, good afternoon. My name is Jake Day, Secretary of the Maryland Department of Housing and Community Development, for the record. I think this is my first time in this role in front of this committee, so it's an honor to be here with you today and with my colleagues. Like I said, I'm pleased to be here and pleased that the chair is sponsoring this legislation on behalf of the department. You have the department's written testimony, but to summarize and provide a few key points as to our intent, House Bill 243 proposes alterations to property tax sale procedures to better protect vulnerable households from foreclosure. Essentially, it would prevent owner-occupied properties from going to tax sale foreclosure because of unpaid taxes and utility bills. And it would provide distressed homeowners more options and more time to pay their debt and keep their homes. When I was appointed secretary, I outlined 5 major objectives for our department. One of them was to ensure that we're providing shelter for all in this state. And part of accomplishing that is making sure homeowners facing foreclosure have every opportunity to resolve the situation and stay in their homes. No one should be losing the roof over their head over especially when we're talking about an asset of the value of the average value that we see of homes over an unpaid water bill or an electric bill or a fairly small amount of property taxes, $1,000 or less. And if faced with that challenge, a homeowner should have ample time as well as a defined, predictable, and affordable procedure to pay their debt and to keep their home. While owner-occupied residential properties represent only a small fraction of all properties that go to tax sale, the owners are often elderly or disabled. They usually live on low or fixed incomes and are disproportionately African-American. Earlier, I referred to $1,000 in property taxes as fairly small, and I think from the perspective of local government, that's true. But for the majority of these distressed homeowners facing a tax sale, that amount is not small. Nor are there unpaid utility charges, nor are the expenses associated with redeeming a property that has gone into tax sale, which can routinely add additional thousands of dollars for these homeowners. In some jurisdictions, the interest rate for redemption can be as high as 20%. If they're willing to pay their debt, they should have the time and opportunity to do so, and they should be able to do it without additional overly onerous fees being added. If they can't pay their debt in total all at once, an installment payment plan developed and regulated by the local government should be an available option. As a former mayor, I understand that property taxes are an important source of revenue for local governments. And I want to be clear that the department respects the authority of local government to levy and to collect taxes for the critical services that they provide. This legislation does not target that revenue stream. House Bill 243 does not prohibit a locality from pursuing foreclosure actions on vacant or abandoned property. In fact, it provides local governments with more flexibility in dealing with abandoned property by authorizing them to offer abandoned property at a starting bid of less than the value of the taxes owed. And House Bill 243 does not prohibit the foreclosure or tax sale of an owner-occupied property. It simply alters the process and offers additional protections for vulnerable homeowners to keep them in their homes as contributors, not only to the economic viability of their community, but to its social fabric. Extending the amount of time before a foreclosure action can be filed, capping interest rates of property tax redemption, freezing the amount owed at the time of tax sale, and providing homeowners with the ability to enter a payment plan rather than being required to pay the entire redemption amount at once will help protect Maryland's most vulnerable homeowners and prevent their displacement. For these reasons, I respectfully ask the committee for a favorable report on House Bill 243. Happy to answer your questions, and I will hand it over to my colleague, Secretary Rokes.
Good afternoon. I'm Carmel Roque. I'm the Secretary of Aging, and I want to thank Chair Atterbury and Vice Chair Wilkins and the committee for the opportunity to come and testify in support of Department of Housing and Community Development's Departmental Bill HB 243 regarding property tax sales. I thank my colleagues, Secretary Day and Director Higgs, for their leadership in crafting this very needed legislation. The Maryland Department of Aging serves as Maryland's state unit on aging, administering federal funding for core programs, overseeing the area agencies on aging, 19 of them, which are the network at the local level that provides services and planning for Maryland's older adults. A key focus of planning and advocating for Marylanders who are in large numbers living longer than ever is to ensure that they are able to afford longevity, to afford longer lives. And this, of course, means supporting older Marylanders staying housed as they age. In a very few years, 6 years, we anticipate that 1 in 5 Marylanders will be 60 years or older. This is a population that is increasingly going to be contributing to the well-being, financial and social structure of Maryland, as well as being in need of additional supports. I'm here to connect the dots with respect to older homeowners in Maryland, often on fixed incomes and wanting to remain aging in their own homes. These are homes that they have worked very hard to own across their lifespan. Maryland's Department on Aging, area agencies on aging, as well as the Department of Housing and Community Development, have various ways that they protect homeowners and work with other local partners to ensure that older adults have support before they become behind in their property taxes and fall into a foreclosure situation. The area agencies on aging consistently encounter older Marylanders through the Maryland Access Point map, sort of front door for all programs and services serving older people. We frequently encounter older Marylanders who are unaware of property tax delinquency or eligibility for certain tax credits that would lighten their tax burden. Complementing the area aging on aging's proactive outreach and options, counseling to older adults falling behind on their property taxes, SDAT's Homeowner Protection Program provides them assistance to help pay off delinquent taxes and fees for homeowners who are at risk of entering into tax sale. 70% of SDAT Homeowner Protection Program applications recently submitted were for Marylanders over the age of 65. Older Maryland homeowners need and deserve assistance preventing the tax sale of their home. As we all know, filing our taxes and staying on top of all the details of homeownership, including our property taxes, can be onerous at any age. I thought I'd share a quick story with you. It's an example of some of what we hear through our area agencies on aging. We recently had a 93-year-old woman who owned her home contact the MAP agency wanting to know how to appeal her property tax assessment. And I think you just heard Secretary Day talk about property taxes being one of the things that can impact the ability of a person to be able to stay in their home. When the staff looked her property taxes up, they saw that she was delinquent on her taxes, and she was shocked to hear this. She had no idea. And she had not been aware and therefore was shocked when she saw her new tax bill. She was also unaware that there were opportunities through the homeowner's tax credits and other vehicles to lighten her tax load. And she had never heard of those or applied for any of those. So I do believe that the thoughtful updates to House Bill 243 will absolutely benefit older Marylanders who find themselves in a foreclosure process or tax sale. And I thank my colleagues, Secretary Day and Director Higgs, for their leadership in crafting this needed legislation. I urge a favorable report for House Bill 243. Thank you.
Good afternoon, Madam Chair, members of the committee. My name is Michael Higgs, and I am the Director of the Maryland State Department of Assessments and Taxation. House Bill 243 would achieve critical equity goals for vulnerable homeowners across the state of Maryland. While owner-occupied residential properties represent a small portion of properties that go to tax sale, the impact on those homeowners can be drastic. In some cases, homeowners, particularly those who are elderly or those with disabilities, are unaware of the delinquencies in tax payments or utility fees altogether and enter tax sale before having an opportunity to rectify the situation. As a result, some homeowners pay up to 20% more than they would have in taxes and fees had they been aware that they were delinquent on payments in the first place. In 2022, thousands of owner-occupied properties were sold at tax sale. It is for this reason that the General Assembly established the Homeowners Protection Program, a widely celebrated program in which the department pays delinquent taxes and fees to local governments and private lien holders to take homeowners out of tax sale. The department then provides the homeowner with a loan repayment plan and works closely with them to identify tax credits and other state resources to build a sustainable financial future. House Bill 243 builds on existing protections for homeowners at risk of entering or who are in tax sale for delinquencies on water and sewer fees, and generally for homeowners at risk of entering tax sale foreclosure. This bill provides an elegant solution to homeowners who are struggling to meet their basic needs without imposing a fiscal burden on local governments. Accordingly, the department respectfully requests a favorable report on House Bill 243, and we'd like to thank Department of Housing and Community Development and the Department of Aging for partnering with us on this very important legislation. Thank you.
Thank you. And to both of the secretaries, I mean, Director Higgs, we see you frequently. We still love you, but we see you a lot. So to the two secretaries, welcome to Ways and Means. We appreciate you being here. Let's give them a round of applause and thank them for being here. We have quite a few other folks that are testifying, but are there questions for Delegate Attar?
Thank you, Madam Chair, and thank you all for this bill. It's a great bill, but I do have a couple questions. I noticed in Mako and MML's testimony, they both pointed out that this is the only way, the tax sale process is the only way to get people to pay their utilities and their sewer. Has that been considered other options? Have you considered other options? Can you elaborate on that a little bit?
You know, in my 10 years in local government, I would just share that, you know, we infrequently use this as the method to get utility bills paid. You know, I think when we did, it was typically larger amounts. You know, I think they're not wrong that it is a mechanism, but I would also say that there are other methods that can be used. You know, we've taken people to collections before. There are other mechanisms. I understand that at the end of a process of trying to work with someone who's unable to pay or unwilling to pay, that holding their property at risk and holding the property as the last vestige of what we might do to ensure that something gets paid seems like appropriate recourse. But let's remember that if people find themselves in these situations, it's because they are already resource constrained. They are already resource limited. They are already in a dire place. And so pushing them to the point where they lose their shelter is probably not the policy outcome that any of us are seeking. And so I would argue that what this bill does do, particularly by adding the provision that I think is one of the most important pieces, which is setting up payment plans, requiring local jurisdictions to set up a mechanism for payment plans for owner-occupied structures, is a critical change that ought to be considered as having merit over and above even the other facets of the bill. So I think I would emphasize that point, that flexibility from the jurisdiction standpoint is one of the most important things that can be achieved through House Bill 243.
Thank you. And I know you mentioned that it happens very infrequently. Would you be able to get me data as to how many times that's happened, a tax sale has happened as a result of that?
Absolutely. We'll
Thank
get that to your office soon.
Thank you. Thank you, Madam Chair.
Any further questions for this first panel? Okay, seeing none, thank you all for being here very much.
Thank you all so much.
Next, Councilwoman Odette Ramos, Shanna Roth Gormley, Claudia Wilson Randall, William Steinwaddell, Stephen Kappen, okay, Councilwoman, if you want to begin.
Thank you, Madam Chair, Madam Vice Chair, members of the committee. My name is Odette Ramos. I am Councilwoman for the 14th District in Baltimore City. I've come before you for several years about tax sale in my prior role as well. And I'm thrilled to see that this bill has been put before your committee. This bill basically provides the protections that many of us have fought for residents against tax sale. So to the rest of the state. So what you see before you, Baltimore City has these protections. And I wanted to let you know that it has been very important for us to be able to work with our residents and not have the stress, particularly during COVID, that anyone would go would be protected in the way that is in the bill relative to tax sale. So we're very much in favor of this. There is one provision that's different than what we normally have, which I think is good, and that's raising the threshold from $750 to $1,000 of where the resident would not go to tax sale if the liens are below that amount. So we're thrilled to be able to share that the protections that we've had in Baltimore City for residents are going to the rest of the state. I think this is great. I will also say that we will still be continuing to work through to completely change tax sale, because in my view, it is predatory. When a lien is sold in tax sale and then somebody has to come and try to collect that debt, they're collecting the debt as well as the fees as well as interest. And it becomes a big burden. So there are, and of course, the effect on our addressing our vacant properties. So I'm just thrilled that this is available these protections are available to the rest of the state, and I look forward to a favorable report. Thank you.
Good afternoon, Madam Chair, Madam Vice Chair, members of the committee. My name is Shana Roth Gormley. I'm an attorney at Community Law Center. We're a legal services provider for neighborhood organizations and nonprofits statewide. So if any of your constituents are nonprofit organizations looking for legal services, that's what we do. And in the course of that work, for the past, I think more than 10 years now, we've been working on tax sale issues because we've really seen the impact of tax sale on neighborhoods, on nonprofit organizations. And this bill is really a step forward in dealing with so many of the issues that our neighborhood groups are coming to us and saying, you know, we're seeing the impact of tax sale on creating vacants, on harming homeowners and destroying generational wealth in our communities. And so this bill, I think, we're really supportive, and we want to see this happen so that some of the protections, as the councilwoman said, that we have in Baltimore are available statewide. And one thing I do want to highlight is that this bill would expand protections as well for churches and other religious institutions that own property, so that their properties don't go to tax sale solely for water bills. I think that's really critical. We've seen a lot of issues in Baltimore City, and I think in other jurisdictions in Maryland, with churches just, you know, dealing with, especially during the pandemic, they might have had issues with their water bills. And so protecting the church buildings from going to tax sale. So that's one of the things that is, I think, really critical. And thank you so much for the opportunity to testify, and I hope you'll vote favorable on this bill. Thank you.
Good afternoon, Chair, Vice Chair, and members of the Ways and Means Committee. My name is Claudia Wilson Randall. I'm the Executive Director of the Community Development Network of Maryland. We are a statewide network of housing and community development partners across the state. And many of our partners are HUD certified housing counseling agencies, are on the front line of this issue. So those are organizations throughout the state that see homeowners with tax sale challenges come to them directly. It is not unusual, as you know, for people in this tax sale, with this tax sale challenge to come in and not know what's happening to them. They haven't received a tax bill or they have received notice. In some cases, their homes have been sold at tax sale and they don't understand what's taking place. Many of these are single African-American women. A great many of them are widowed, may have lost a spouse in the last 2 to 3 years, or a child, and really had someone taking care of the tax bills, okay? And the other thing that we routinely see in these organizations is that people are also sick. They may have chronic illness, diabetes, high blood pressure, dementia, so their health is declining. So we see this throughout the state. We see it in Baltimore City, Prince George's County, Dorchester. It is not uncommon. I'm here today in support of House Bill 243 because I think it makes a lot of really key changes. I think raising the threshold to $1,000 is really important. Payment plans is critical. High interest rates that what it takes to redeem some of these properties and having to pay the municipality, having to pay the purchaser, it's confusing. So I hope you will be in favor of House Bill 243. And I also really want to applaud this administration for collaboration between Department of Housing, Department of Aging, and SDAT. Great job. Thank you so much.
Hello, my name is William Steinwittle. I'm the supervising attorney for the Foreclosure Legal Assistance Project in Maryland Legal Aid Bureau, the largest nonprofit law firm in the state of Maryland. I'm going to focus on two of the reforms that are proposed by this bill and why we are in strong support of them. The first one is as Ms. Randall stated, the increase of the threshold to $1,000 for properties to go into tax sale. I once represented a client who paid her property taxes and earned credits where she only owed $400 a month, $400 a year in property taxes. But because her income was so low, she could not pay that. Her son, who was killed in Iraq, had all of this stuff that she had to sell just to save her house and just to pay $400 in property taxes. Because unfortunately, the property tax credit does not cover the entire bill in Baltimore County, Prince George's County, and Montgomery County. In addition, the other reform in this bill that this bill proposes that we support is the increase to 10 months as opposed to 6 months to redeem before attorney's fees are added and a year before a complaint to foreclose the right to redeem can be filed. I've been a lawyer for over a decade, for the last 14 years, and I try not to get preachy and attack the other side, but the abuse that I've seen in the tax sale industry is important by the people that represent the tax sale purchasers. I once had to litigate a case all the way to the Supreme Court of Maryland simply because the tax sale purchaser attempted to try to cut off the ability of the person to redeem and abuse the tax sale process. I think these reforms go a long way to making that situation much less likely to occur. And for those reasons, Maryland Legal Aid is in strong support of House Bill 243. Thank you.
Chair Atterbury, members of the committee, my name is Stephen Coppin, and I'm a staff attorney at the Maryland Volunteer Lawyer Service. I work directly with property law and estate administration issues, so I interact with tax sale a lot. HB 243 is a critical reform. We think that the increase of the threshold to $1,000 is essential, and even more, it's even more striking when you put it in comparison to where some of the thresholds are currently set. At $250, $750, $1,000 is a critical reform to initiate a tax sale. I want to bring up some of the data that we collected at our 2020 tax sale clinics about who is affected by the tax sale. And these are the people who are losing their homes to the tax sale. 72% of our clients were seniors, 48% were disabled, 85% identified as Black, and 72% reported household income of $30,000 or less per year. Many of these clients survive on fixed incomes and struggle to pay their bills even before a tax sale is initiated. By increasing the threshold, this bill will keep low-income Marylanders housed, and by putting a critical cap on interest rates, it will keep small bills from becoming inhumane burdens on the most vulnerable members of our state. It will also lead to more people redeeming their homes. HB 243 in this way advances equity and protects the vulnerable. MVLS has been fighting to even the playing field for low-income Marylanders for decades. And we know that poor Marylanders are most often forced to face tax sale without an advocate. This imbalance of power makes it more likely that our clients will continue to struggle to get out of tax sale. We support HB 243 because it would provide the entire state with a common sense tax sale threshold and limit the interest on the rate of redemption of homeowners trying to reclaim their homes. So we support a favorable report. Thank you.
Thank you. Any questions for this panel? Delegate Patterson.
Thank you, Madam Chair. Thank you for this legislation. As I'm listening to the presenters, I'm reminded of some cases we worked on in Charles County, and they too, like you've described, they were senior citizens. So my question is to one of the attorneys, in terms of tax sales, what communication is offered to the person when they receive the information? You cited that you do pro bono work. I mean, is something sent along with the notice of potential tax sale to say, in this event, please confer with XYZ service or pro bono lawyers, etc.? Is that done?
I believe the Pro Bono Resource Center and another one of and maybe MVLS as well, I believe they do send out a notice to all the properties that are listed in the tax sale for Baltimore City. Now, I don't think that notice, though, however, is sent to any of the other counties. Now, the statute requires that before they can proceed with a complaint to foreclose the right to redeem, or even to add attorney's fees, the two notices be sent to the owner of the notice of the tax sale via certified mail. But I will say, in my time as an attorney and handling these cases, I have seen abuse of that required notice.
Finally, would this passage of this legislation correct that omission?
Well, it would certainly provide more time, which is always the best thing, because so this is the second time this has been proposed, and it passed last year. So last year it went from 4 to 6 to 7 to 9, and now it's 10 to 12. And the more time always makes it more likely that the homeowner is going to get the property tax credits, is going to be able to speak to counselor or a housing counselor or somebody that can help, and is going to make it more likely that these houses are redeemed and avoid going into a complaint to foreclose the redeem, avoid the owner losing ownership of the house due to property taxes being owed.
All right, thank you.
Any further questions? Okay, seeing none, thank you all very much. Next, Dan Ellis. All right, so Dan Ellis is favorable and the other folks are favorable with amendment. Ari Clout, Heidi Kenny, Frank Boston, and Michael Eskenazi.
Oh. Take a picture of this.
So if Mr. Ellis could go first, please. Oh, hug it out.
We're never on the same channel.
Okay, Mr. Ellis, I didn't have enough seats up there for you before. I'm sorry. But if you could go first.
Sure. Thank you, Chair Atterbury and members of the committee. I am Dan Ellis. I am the Chief Executive Officer of Neighborhood Housing Services of Baltimore. At NHS, we believe that economic and social justice is a right for all people and communities. There have been many protections in Baltimore City that we have worked hard to put into place over the years that have protected the most vulnerable homeowners in Baltimore City. We are excited to see House Bill 243 sponsoring the extension of those protections across the entire state. The bill also extends the protections further in Baltimore City in a couple key places. One place is raising the threshold statewide to $1,000 for an owner-occupied property to go into tax sale. The threshold right now in Baltimore City is $750. Throughout the rest of the state, it's typically around $250. In Baltimore City, a number of years ago, when we raised the threshold from $250 to $750, the following year, it meant that about 2,500 homeowners were not in tax sale, who without that change would have been included in tax sale. Many of the people who are in tax sale are often the most vulnerable homeowners, the seniors, those who have paid off their mortgage, heirs properties, because they're not having an escrow that's being collected to pay their taxes. So these are often the people that most are in need of our help. The other change, or another change that is done by House Bill 243, is that it extends the timeline for which a property can be filed, which the first notice or which the first filing can be made, which is really where the fees begin to accumulate on the property. It extends it in Baltimore City from 7 months to 10 months. That additional time, as has been previously testified, really provides assistance to help people have additional time to move forward. So our goal is to protect the most vulnerable homeowners. We're excited that House Bill 243 provides those protections and extends them statewide. We thank Secretary Day and his colleagues for their leadership in this space and request a favorable report on House Bill 243. Thank you very much.
Good afternoon, Madam Chair, Madam Vice Chair, members of the committee. My name is Ari Plout. I'm from Boston Plout Law on behalf of the Kenny Law Group and the Maryland Tax Sale Participants Association. And we support this bill, but we do have an amendment that we would like to bring to the committee. So basically, the purpose of, you've heard testimony, the purpose of the bill, we want to protect vulnerable homeowners. And we believe that if the policy is to protect vulnerable homeowners, we would recommend an amendment to narrow, with regards to the water bill portion, narrow the definition from residential to homeowner occupied, because this will protect the vulnerable homeowner population. However, it would also, if you narrowly tailor it, this would encompass, excuse me, if it's too broad the way it's written. So we believe if you narrowly tailor it, it would protect the homeowners, but also leaving, not leaving the landlords, leaving landlords that may not pay their water bills. So with that, we would ask for a favorable report on support with the amendment. Thank you.
Good afternoon, Madam Chair, Vice Chair Wilkins, and members of the committee. We are in favor of House Bill 243 with the amendment that Mr. Plout just spoke to, by making sure that the legislation does what it's intended to do, and that is to protect homeowner occupied properties and not just the broad category of residential properties. We also are requesting amendment to remain for the time of filing for 7 months. Those protections have been put in place for over the several years. In fact, there was a bill introduced last year that passed, that was put in by the State Department of Taxation, that allowed homeowner occupants to request a statement that was valid for 30 days. But if we continue to chip away and extend the time for filing, it impedes on the statute of limitations for the tax sale certificate. And if we do that, the time that we can file is narrowed. And if homeowners are then asking for statements, the statute of limitations for the foreclosure will then expire before we were even able to file the case. So in essence, narrowing the types of properties that are placed in tax sale also limits the amount of revenue you're collecting. So we want to be very careful that it's just limited to homeowner occupied properties. Thank you.
Madam Chair and members of the committee, I'm Frank Boston III. I'm here today on behalf of the law offices of Heidi Kenny and the Tax Sale Participants Association. And we, as you've heard from the testimony, support with amendments. We certainly support the purpose of the bill. And we just think, as you've heard, it should only apply to owner occupied properties as it pertains to water. If the true intent is to protect grandma from losing her home, and the intent or the unintended consequence should not be to protect the vacants, the abandons, the commercial or the slumlords. This amendment helps fix that and really narrow, as Mr. Plout was saying, the actual focus of the bill. And one little note that I want to leave with you is please keep in mind that 95 to 97% of the properties that go to tax sale eventually get redeemed. With that, we'll stand for questions.
Okay. Good afternoon. My name is Mike Eskenazi. I am a licensed real estate agent who's lived and worked in Baltimore for the past 9 years. I'm here on behalf of the Maryland Tax Sale Participants Association. We are dedicated to the continued improvement of the Maryland tax sale process. We believe tax sale should be administered according to principles of fairness, equity, and transparency, while continuing to enable Maryland jurisdictions to collect vital delinquent property tax revenue. We believe HB 243 should be amended so water bills should only be removed from tax sale for owner-occupied properties, not for investor-owned properties. Water bills were originally removed from tax sale at a time when the water department had switched to a new water billing system. Kinks in that system led to excessive water bills that caused struggles for low-income residents. Fast forward to today. Many of the kinks in that system have now been worked out, and the vast majority of Baltimore owner occupants have been removed from tax sale for the past 3 years. In today's context, the decision to remove investor water bills from tax sale is really just a relic. It is good policy to re-include these properties into tax sale. Tax sale, after all, is the impetus that gets delinquent taxpayers to pay their taxes. In Baltimore City, a whopping 35% of city property taxes are collected after delinquent tax sale notices are sent out. We previously heard testimony from DPW that removing Baltimore City water bills from tax sale resulted in Baltimore City water collections decreasing substantially. We now regularly see properties with $10, $20, even $50,000 water bills because there is currently no mechanism to collect. Shouldn't non-owner occupants, investors, landlords, and derelict property owners be expected to pay their bills? What would be so I apologize, I have a bit more, but basically we strongly urge the passage of this legislation with the amendment that water bills be re-included into tax sale for non-owner occupied investor properties. Thank you.
Thank you. Questions? We'll start with Delegate Wells.
Thank you, Madam Chair. My question, because there was a lot of focus on the distinguishing between owner occupied and then investor and non-owner occupied. So I'm curious, in that scenario, and when you look at that, what does the scenario look like for perhaps myself? I'm a landlord. I'm not one, but if I were, and Mr. Boston is my tenant, he's a great tenant. Pays his bills, he pays his rent on time, but I might be a little bit behind on paying on my taxes. So I'm curious, where in that type of scenario, is there some type of room for opportunity to not have that home, which is a rental, which is providing valuable housing to someone in the community? Sure. Is there a scenario where, in that case, someone would be covered by the bill proposed before it says it?
So I'm happy to answer. So in that scenario, I would hope that the rent payment is budgeted in to cover the cost of the maintenance of the property and the taxes and insurance, which is what most obviously you want it to be profitable. So I would actually state that there are more protections in the tax sale property tax statute right now for tenants than for homeowners, because tenants actually get the opportunity to redeem if the property is in tax sale. And also if it got to a point where a foreclosure was impending and, about to happen, there is a provision that requires notice be given for the tenants to either find additional housing, but there's also the opportunity for the tenants to have a discussion with the plaintiff in that case, whether since they're a good paying tenant, why would they not want to remain in the property? And that would be the discussion that is the opportunity that you don't have when it's a homeowner occupied property.
Okay, well, so the real question I have, and I don't know if you quite answered it or not, but basically is that would there be any protection, since that's not a home owner occupied property, is there some kind of, not protection for the tenant, but is there some type of pathway where that non-owner occupied rental would be able to perhaps benefit from the tax programs that are being discussed? That makes sense.
I don't know if they would be if those property owners are eligible under the current programs available, because they are narrowed to people who own their home and live in them.
Okay, because my concern is that if we only do owner occupied, maybe it's a small segment of the population that is a rental. I'm concerned that could that potentially lead to a tenant unfortunately being not evicted or, non-renewal of their lease is where I'm a little bit concerned about the possibility of that happening. That's all. When you mentioned only limiting it to owner occupied.
Right. And I think that also the point is that a lot of times if a property owner in that scenario, the landlord is not paying the taxes, there's a lot of other things happening in that property that they're probably not doing as well.
Okay.
So that would be a case by case.
Thank you.
And just as a practical matter, an investor, if there's a tenant that's paying their rent, they take over the property. They want that tenant to stay there because they're going to continue to pay the rent. That's how it plays out.
Delegate Buckle?
Thank you, Madam Chair. Oh, thank you. I know that Ms. Kenny, Mr. Boston, remember this. We had a whole committee a few years ago. We had a task force on the reform of tax sales. I know because I served on it. We drove down here dozens of times. It felt like, and it was only a few years ago. And yet, every year or 2 years, it seems like we're trying to radically reform the tax sale system. Since the reforms that were implemented as a result of the task force a few years ago, have any of you noticed or are any of you aware of any information that somehow the process has changed, or there's been more instances that need this massive reform now? And what's changed? We sat here 5 years ago and said, this is going to fix problems. We did it. And now we're told that, well, none of the problems got fixed. So now we have to massively reform the system again.
Yeah, so if I could, well, if it's all right, I'll chime in. Basically, we have seen a tremendous number of reforms over the last 5 to 10 years. And the problem, to your point, I think, is that a lot of times we're not even waiting to see what the results of those reforms are before we come back around the next session and people, say, hey, let's make this reform and let's try this other good idea. And one example, pursuant to my testimony today, is the water bills. There was a real problem, with the city's water billing system. It was negatively impacting low-income residents who were getting these bills that were kind of out of whack, and probably the water department didn't recognize to enough of an extent that, yes, something needs to be fixed here. And so kind of this stopgap measure of, okay, well, let's just take water bills out of tax sale was put into place. But there are real unintended consequences there. You now have essentially a system, the city does not, as a practical matter, turn off water to its residents, and you now no longer have a means of collecting the water because the bills don't go to tax sale. And so you had DPW testify like, hey, this sounded great on its face, but now we have all this delinquent revenue that we can't collect. And
and so that's something that I would ask. I know some of you are Baltimore City oriented, and there's been a tremendous problem, obviously, with the bureaucracy of Baltimore City and maintaining this billing system. But I haven't heard of what you're now talking about in this bill, if I read it correctly, is taking that limitation, which I supported. I think Mary Washington sat right where I was sitting, and I sat right there when we did that a few years ago because of the problems that occurred in Baltimore City. We all supported that of, look, we're not going to let you take someone's property away because you've screwed up your system so much that it may be grossly unfair. Now we're trying to import that to all 24 jurisdictions. But I got to tell you, where I live, I've never heard of this kind of problem at scale. I've never heard of it being in the press in Anne Arundel County or Harford County or Charles County. I've never heard of these kind of situations. So what's the utility of expanding something that was done for a particular jurisdiction for a particular problem and now saying we're going to take it everywhere? I think to your point, if I live in Cumberland, Maryland, and just decide, hey, I'm not going to pay my water bill. I can only get my water from one place, from the city of Cumberland, then they can't turn me off. And at this point in time, I just won't pay the water bill, and maybe that'll go on for 3, 4, 5 years, and I'll owe $10,000. How does that help me? I mean, why should we do this statewide when we did it originally to address a very specific particular problem?
And that is why our position is that it should at least be narrowly tailored to owner occupants and vulnerable low income people who would actually, need benefit and need that help, as opposed to just, using a fire hose and spraying it at this problem. And then you have all these other unintended consequences from not getting water revenue from the people who should be paying, the investors, landlords, delinquent, and derelict property owners. So that's what we're saying, at least narrowly tailor it to the people who need the help.
And I had only one other question, Madam Chair, and I can address this to Ms. Kenny or Mr. Boston, whoever's more interested in answering it. So the redemption rates, the rates of interest, the sort of the investment rate that you get, when I first started getting involved in tax sale stuff from a legislative perspective, I thought, because this normally applies where I live, where I'd done it legally for people who went in and bought tax sale certificates, they were really, really desirous of owning the properties. They thought that they saw an opportunity there to purchase something at tax sale and convert it to a more beneficial use, a property that had been allowed to go up for tax sale, been run down, maybe it was vacant, it could be developed in the future. What I found, though, is that across the state, you correct me if I'm getting this wrong, the vast majority of tax sale investors who purchase the certificates and thereby fund counties and municipal budgets that are getting otherwise unfunded from the tax sales or from the tax bills. They're in fact investors per se. They are people who are making a decision that says, I could go out and invest X amount in some other commercial investment and receive a rate of return, or I could invest in this. Do you think that lowering the rates of return available to the tax sale certificate purchaser would dissuade them from participating in the sales at all?
I do see that occurring. I have seen over the course of me doing this, which is probably decades, and I have seen where large banks have come in from national banks to invest in the tax sale of in the state of Maryland. And over the course of time, I've seen that slowly diminish. And now I'm seeing where there's more small time investors with the intention of they're buying the opportunity for exactly what you're saying. But what people who don't do this are not understanding is that it is all a numbers game, and you have to buy in quantity to make your return. So when you say we're going to cut the interest rate to 10, what you're not understanding for members of the committee is that that's really not a 10% rate of return, because you have to, in some jurisdictions, put up a bid premium that has no interest bearing, that then lowers your rate of return to probably 2%. So lowering interest rates across the board for like what you're getting is not an accurate picture of how tax sale really works. And so there's a lot of other factors going into it. So first of all, you have to be in a position to buy the quantity to make the numbers work out. And you have to play that against what you're putting up in bid premium that receives zero interest on the return.
And so when we see a 6 to 10% spread is proposed in the bill, it would seem to me, if I was a county or a municipality, the worst case scenario would be I have 100 properties, no one's paying the taxes on them. I put for years. It's not as if you just didn't pay the taxes once. I think it's 2 years. 2 years in a row. I put the property up for tax sale and no one bids on the tax sale because the rate of return, the investment just doesn't make sense in today's economy. You can put money into a lot of other commercial interests and get 4, 5, 6, 7% yearly returns. What happens to those properties then?
So I would imagine that the investor is like putting out money to buy as many properties as like the 100 properties you gave as an example. They're probably bidding on the properties with a portfolio rate of return estimated at a 2% to 3% return, with the hope that one of those 100 properties gets to the final stage of foreclosure so that they can purchase, obtain the deed, rehab it, and sell it, which would then fluctuate the entire portfolio rate of return to a higher rate.
That makes sense. Thank you.
One
Wait,
more
I think-
thing that, oh, I'm sorry. Go ahead.
Any further questions? Okay, seeing none, thank you all for being here.
Thank you.
Kevin Canali, favorable with amendment, unfavorable, Angelica Bailey Thupari, and then we have two folks virtually. Whenever you're ready, Mr. Canali.
Good afternoon, Madam Chair, members of the committee. Kevin Canali here on behalf of the Maryland Association of Counties in support of the bill with amendments. You've heard a lot about this bill and a lot of the provisions in the bill. You do have my written testimony. I just want to raise a few points about the bill. First of all, we really appreciate the flexibility on vacant and abandoned property. That's a problem across the state. There are a lot of great pieces in this bill that we have no concerns with. There are fiscal components in the bill. There are unfunded mandates in the bill. And really the biggest, from our perspective, it's not necessarily about water and sewer. It's about the tax software that many counties use. And some of the most ubiquitous software out there does not allow for the separation of owner occupied versus non-owner occupied. And so to complete these reports, counties have been hiring people to go through by hand, thousands and thousands of properties, and try and weed these out so that they can report to the state ombudsman. I also want to point out that the state makes counties and municipalities do this. This is not a local decision. Counties have to take this debt to tax sale. So I know there's a lot of conversation that this is inequitable. This is state law. And so we have been here for the past few years supporting bills to reform the process, including the homeowner protection program. And that works well. For payment plans, only last year did the General Assembly authorize counties to adopt payment plans for tax sale. So we haven't even really had time to see how that will work. And it's not necessarily a provision we disagree with, but I do want to point that out. The other thing our folks really want to make clear, there's a lot of concern about this bill. By raising the thresholds, you're not necessarily keeping people from tax sale, you're only delaying the inevitable. And as those charges and taxes continue to accrue, it may be more difficult for the person to actually redeem once they do meet the $1,000 threshold. So I do want to make that clear. There is concern about that right now people are it's a lower threshold, and it's just the opportunity to take something to tax sale, putting it in the paper, that solves the issue more times than not. It's just being in the paper. There's a great chart in here to show you the average liens. They're over $3,000 for owner occupied. So we're really not concerned, but there is an argument that this could make it harder to redeem for people who need the most help. And with that, we'd ask for a favorable report with amendments.
Good afternoon, everyone. Angelica Bailey Thupari. I'm the Advocacy Director for the Maryland Municipal League. We are in opposition of this bill. Very respectfully, we appreciate the department's intent here. We are invested in ensuring that we have safe housing for our residents, but this does constitute a pretty significant unfunded mandate and would have some negative pragmatic implications for our members. We represent 160 towns, cities, and special taxing districts all across the state. That's home to almost 2 million Marylanders. Our members are simply too diverse for a one-size-fits-all approach that we see in this bill. Many towns have limited resources to provide quality services, as Secretary Day mentioned earlier, let alone to slow or mitigate blight, which is a major concern. Of course, we don't view tax sale as a cash grab or a revenue generator, and we do what we can to prevent it, but we do need a reasonable stick of sorts, and this weakens our options. The rate of redemption on this bill is simply too low. We would have to wait a year to be able to assess reasonable penalties. This also weakens the consequences of tax sale. The bill also would let taxes climb to $1,000 before requiring towns to provide a mandatory payment plan option. First of all, many of our members report that they are already utilizing payment plans and at a much earlier stage in the process. But it also waits before recouping fair and reasonable assessments. That's going to be tough for our budgeting purposes. And if a payment plan is the goal, then why wait a whole year before starting to work on one together? This legislation also bars local governments from using the tax sale process to collect unpaid water and sewer service charges. That leaves us very little hope of collecting on that money, especially in jurisdictions that prohibit water shutoffs. So tax sale, it's one of the only meaningful tax collection tools that we have. We do try to balance that with protecting vulnerable homeowners. The Homeowner Protection Program, HPP, is a much better solution to address the concerns in this legislation. So we ask for an unfavorable report. Thank you.
Thank you. Any questions from the committee? Okay, seeing none, thank you very much. We have virtually Allison Harris and then Scott Moore. So Ms. Harris, whenever you're ready.
Good afternoon. I'm Allison Harris, Director of the Home Preservation Project at the Pro Bono Resource Center of Maryland. I'm a legal services provider of tax sale prevention services, testified in favor of HB 243. There's a lot here in this bill that will mean that fewer homeowners will end up in tax sale and more homeowners will be able to redeem if their lien is sold. I want to put a human face on the homeowners that we are talking about here today at this hearing. My client, John, is a typical example of a homeowner in tax sale. John called me days before the Prince George's County tax sale auction. He was in his mid-60s. He'd been working as a teacher before he was forced into retirement in the early days of the COVID pandemic. John had owned his home for over 30 years, paid off his mortgage, paid his property taxes every year on time for decades until he lost his job and became reliant on Social Security for income. Like many senior homeowners, his property taxes increased dramatically over the years, and then suddenly his income was reduced significantly. He fell behind on his taxes and his water bill. John did everything he could to come up with money to pay his taxes and his water bill. To make money, he went door to door in his neighborhood, offering to trim trees and do yard work for cash. He scrimped by eating sandwiches out of the dumpster at a nearby deli. The lien certificate on his house was sold, and John was devastated and desperate to save his home, his only asset in the world. Over the next few months, we worked together to redeem and save his home, but he needed all of those months to get himself sorted out. It took time to put all the pieces in place, and every extra dollar that reduced his financial burden to redeem was needed. Once stabilized and receiving the homeowner's tax credit, John asked me if there was a way he could pay more than the tax limit that SSAT set for him. He would trim more trees and mow more lawns to pay if he could, because he wanted to be a good county resident, a good neighbor, and a good taxpayer. This is who we're talking about when we're considering this legislation related to tax sale. HB 243 would mean fewer people like John would find themselves in this situation in the first place. Thank you for the opportunity to testify.
Thank you. Any questions for Ms. Harris? Okay, seeing none. Thank you, Ms. Harris. Next, finally, Scott Morse, please. Oh, he's not here? Okay. Thank you. Then that concludes the testimony on House Bill 243. House Bill 248, Director Higgs.
That was quite a hearing. Good afternoon, Madam Chair and members of the committee. My name is Michael Higgs, and I am the Director of the Maryland Department of Assessments and Taxation. House Bill 248 would consolidate the department's 24 Rio County assessment offices into 8 regional offices. The bill would also consolidate all 24 county property assessment appeal boards into 8 regional appeal boards and clarify the staff on the department's property assessment teams cannot also serve their appeal boards. In its ongoing process to find efficiencies in its services, the department has identified significant challenges in its county real property assessment offices due to strains on current funding and staffing. Last year, the department's Anne Arundel County Assessment Office had 0 commercial property assessors on staff, and our Prince George's County office consistently struggles to retain quality staff, for just 2 recent examples. County offices already have limited flexibility to shift assessors to meet the state's property assessment needs, a process which brings millions of dollars in revenue that local governments rely on across the state. The department's inefficient management structure currently sees it paying for 24 county offices, along with necessary staffing redundancies, expenses that become less necessary as new technologies allow assessors to move away from making as many in-person assessments. Furthermore, the department is required by statute to assess 1/3 of the state every year, which is accomplished by assessing properties in 1/3 of each county every year, a workload which varies greatly from county to county. By consolidating offices, the department will still be able to shift the assessment and management workload around much more efficiently. House Bill 248 would give the department more flexibility to allocate resources as necessary and reduce wasteful spending on offices that no longer require a physical presence in every county by consolidating all 24 offices and appeal boards in 8 regional offices. If passed, this legislation would allow the department to shift resources to ensure a more accurate and efficient assessment process while being a better steward of taxpayer dollars. In a challenged budget environment, this timely legislation allows the state to more efficiently and effectively generate vital revenues for our state and local government and deliver a higher standard of service to the public. I'm going to go away from my notes for a minute here. There were 3 choices that we have for the future of the assessments program in the state of Maryland. We can continue to do nothing and run a program that was set up in 24 county offices at the state level, but not get the resources to properly manage it that way. We can turn the county assessment functions back over to the counties, the way it's done in just about every state, everywhere else in the country. We've tried that many times. MACO and the counties have balked at this suggestion. So the only choice that I see left to continue to deliver quality data to our county finance office partners that rely on this so much for hundreds of millions of dollars of revenue is to allow us to run this program as if it's a state program. And right now it's being inefficiently run as if it was a county program at the state level, where 90% of the revenues are being generated, go to the county governments, 10%, give or take, come to the state. There's a 50-50 revenue split between the two. It's the incentives are a little bit misaligned, and I think that this bill will help us come up with a much more efficient and effective organizational structure that can really improve our data collection abilities. And let me leave you with one little number here as I close my testimony. $34 million per percentage point of assessment accuracy. That's what our assessments are worth to the local county governments out there. $34 million per point of assessment accuracy. When we first arrived, my team first arrived at SDAT, the agency was hitting assessment metrics in the 96-97% range. And consistently, we're being told by the administration, previous administration, to learn to do more with less. Just figure out ways to do more with less. And our budget was hit every single year. And I've been told from my predecessors that their budget was hit every single year as well, to the point where we have more properties in the state and fewer assessors than ever before, far fewer than other similarly sized governments out there. And for every percentage point that we're off, that's $34 million is costing our county governments. Right now, we're down around 90 to 91% assessment accuracy. I would really love to see us get back to that 96-97% range and provide more equitable tax distribution for the state and keep that solid revenue stream going for our county governments. Thank you.
Thank you, Delegate Buckle.
Thank you, Madam Chair. Thank you, Mr. Secretary, my friend. 2 questions for you. Number one, would the sort of streamlining or the regionalization of these offices result in job losses?
No, nobody needs to lose any jobs. I have more work than I know what to do with right now. What I need to be able to do is reform my workforce. Right now, the way the law is, I have 24 county supervisors, 24 county assistant supervisors. What I really could use is a management structure that's built a little bit more like a pyramid than a flat mini mall. And
Sure.
If you look at any management guide out there in the world, management classes will teach you that that's a very inefficient structure for getting good work out of your organization.
So do you intend to offer employees to be able to work almost wholly virtually? And that's, I guess, kind of the question too, because if you close an office in Garrett County where 2 or 3 or 4 people work and you tell them that your day-to-day report is in Hagerstown, they're not coming. You might have a total overall job, you're going to hire new people, but it's not going to be those people. If you told people in Baltimore City, perhaps, that our new regional office is in Bel Air in Harford County, because that's our region, those people may not be coming. So to me, I guess the question is do you plan to let people continue to generally work where they currently live in some form or fashion, number one? And number two, have you already entered into the decision tree of where the regional offices would be placed?
We embrace telework, I think, more than any other agency in state government, and we still firmly believe in it. It is deeply entrenched in our structure. We are continually trying to update our systems to be able to allow for greater levels of telework while not losing any of the customer service that we've been known to provide over the last several years. And I have promised my people, I put out a memo to the department promising that this would be a very humane transition. I'm not just going to rip the tape off and make a decision that the next day it's regionalized. It's going to be a slow rolling process, office by office, region by region, and we are certainly going to include telework in the transition. And I don't want to see anyone losing their jobs. I understand that there will necessarily be some transition of people who are either, just decide that commute's too much and they're going to self-select to something else for the times they do have to go to the office. That is definitely a bit of a situation that I wish weren't the case, but unfortunately, change of this nature is going to be difficult, but I'm going to do everything I can to make it as employee-friendly and customer-friendly as possible.
And one just quick final question. I don't think you talked a whole lot during the presentation, but this also reorients the property tax assessment appeal boards, correct?
Yes.
So that instead of I have an appeal of my property tax and I go into a board that's composed of people, say just in Baltimore City, the way that you've got the regionalization, Baltimore City is now lumped together with Harford County and Baltimore County. So that PTAB would now have people from Harford County evaluating the property tax assessments for people in Baltimore City. Do you think that that's something that they would be, sort of have the level of expertise to do in general?
I don't think that you need to know each particular neighborhood in a jurisdiction in order to be able to hear an appeal. They are presented with both sides of the case, with comparable properties from the appellant side and comparable properties from the agency side. We look at the data that was collected and used in the assessment, and it's a very heavily data-driven process. And I think that not having an intimate knowledge of one particular neighborhood or another would not preclude that job from being done properly. I also know that the appointments office for the governor has a lot of difficulty finding quality people to staff and fill these roles for 24 boards across the state. So this would also, regionalizing would make it much easier to find quality people who are dedicated to the mission of ensuring fairness in assessments.
Thank you.
Delegate Hornberger.
Thank you, Madam Chair. From what I can gather here, you've already demonstrated the ability for this organization to come into the 21st century and be remote and be effective. So if that already exists and you're going down to what you've got projected here is 8, why don't you just go down to 1?
Because I feel that we do still need to have some sort of a regional tie and to be able to leave assessors to where they can hit properties when they need to be when we need boots on the ground. It's less and less necessary to put a physical presence on the property, given our access to oblique area imagery, to much better data sources. Right. That it needs to happen less often, but it still does need to happen often enough that I think a regional structure would be better. There's less of a need for people to be in person in the office for any reason, but even appeals, much more moving toward virtual appeal hearings. So there's not less of a need to be in the office. But that said, we also have a whole bunch of supervisors that have told me they would like to continue to hold appeal hearing days at county libraries, even after they regionalize. So, we could still have, even if your county doesn't have a regional office, we could absolutely still have dedicated appeal days where we come down to the county seat that doesn't have a dedicated appeals office and do appeals that way.
Having worked in this industry, hoteling, you can use these other spaces if you do have to meet with your clients, your constituents. But to drive from one corner of Cecil County to the other is a little over an hour. to drive from what you've got proposed here, Cecil to Talbot, could be as much as 3 or 4 hours. So if I'm just splitting the difference and saying everything's right smack dab in the middle, you're still looking at a commute time for either the employees or that constituent of 2 hours each way. So in 2 hours, I can just assume be in Annapolis, an hour and 15 minutes. So I'm just not following the logic of going from 24 to 8. Whereas if the model is true that you can consolidate, why wouldn't you just go to 1? But I appreciate your answer and applaud your efforts to streamline operations.
Thank you.
Delegate Hartman? Yeah. That was it, okay. Any further questions from the committee? Okay, seeing none, thank you very much, Director Higgs. Kevin Canali, and then favorable with amendment, following him, unfavorable, Bruce Bariano.
Good afternoon, Madam Chairman, members of the committee. Kevin Canali here on behalf of the Maryland Association of Counties in support of House Bill 248 with an amendment. A lot of discussion already generated on this bill. I think a lot of good points have been made. I think from a county government perspective, this bill has generated a lot of discussion across the state. Our county elected officials and your shared they're hearing from your shared constituents about this bill. And I think anytime you talk about changes to property tax assessments or regionalization of offices that handle appeals or supervisors, that gets people's attention. So our amendment here is that we'd like to have a public process. We have no issue if SSTAT feels like it can streamline operations, but what we would request is that each county affected would need to sign off before a region could happen. And that way their constituents can come and have a public process to explain why it's a good or a bad idea. I also want to remind people, the previous testimony talked about Maryland and our structure and why we do it this way. The state does it the right way. And let me remind you why. In many states, there are terrible stories when counties own this process. So if you can own the process by which you collect revenue, in some states, you have terrible stories about local governments asking their assessors to go out and find more money. The state handles this because they have no incentive to go out and do stuff like that. This way, you don't have the fox guard in the hen house, right? So this is the right way to do it. The state has no incentive. We don't want counties to have to own this process. If we pay for more than 50%, as has been proposed in years past, we will own it and we will be more efficient. But we're not going to pay more than 50% for something that we can't control. So I understand the argument. We want SSTAT to get the budget it needs to do its job, and we hope that the administration will do that. We hope the General Assembly will support those efforts. They certainly need help. Understand the intent here to regionalize so that they can hire more assessors and be more accurate. Those are all great things. And again, we don't have an issue with that. We just think there should be some kind of public process locally, especially with the feedback we've gotten. So with that, we'd ask for a favorable report with amendment.
Good afternoon, Madam Chair, members of Ways and Means Committee. For the record, Bruce Bariano. I'm here on behalf of Queen Anne's County, Washington County, and St. Mary's County, who I represent. Very strong opposition to this legislation. If they have budget problems, they should be before Ways and Means. They should be before appropriations of budget and tax. But very sincerely, this bill hurts your constituents and the businesses in your district. It is just for their benefit and not for the citizens of the state of Maryland. The regionalization is going to make it far more difficult for people appealing and people complaining or calling and wanting answers to their tax assessments. And it's not going to help at all. You've heard from some of the witnesses, some of the members' questions. There are real problems with this at all. And let me tell you something else, which I think is very relevant, that MSTAT did last fall, which again shows, in my opinion at least, they are not customer friendly, and they're just doing what's convenient for them and not what is best for the taxpayers. Maryland law gives every property owner the right to appeal an assessment notice within 45 days of that notice. For decades, the State Department of Assessment has enclosed in what they send you in the mail an appeal form with a notice of reassessment for aggrieved taxpayers that they can use to appeal their assessment. Against the advice of the department's career real property managers, the director of SSTAT has eliminated the appeal form from being put in the envelope and sent to taxpayers.
with their notices. Instead, taxpayers are directed to call the local assessment office and request an appeal before they can appeal, just making it all more difficult. This bill further makes it that much more difficult for taxpayers, be they residents or they be businesses. Please vote unfavorably on this bill. Thank you.
Thank you. Any questions, committee? Okay, seeing none, thank you both
Thank
very
you, Madam.
much. And that concludes the hearing on House Bill 248. House Bill 371, Delegate Grossman.
Madam Chair, Madam Vice Chair, and members of the best committee ever. For the record, I am Delegate Brooke Grossman, and I'm here to testify on behalf of House Bill 371. House Bill 371 will provide an overdue update to Maryland's recount laws. In recent years, we've had several extraordinarily close elections, including the race for Baltimore County Executive in 2018 and Montgomery County Executive in 2018 and 2022. This bill would revise Maryland's recount law to allow for one of the following recount options: a rescan of voter paper ballots involved in the recount using precinct tabulators or a high-speed scanner, if available, to reproduce early voting, precinct, mail-in, or provisional ballots canvass totals, or conduct a manual recount of voted paper ballots involved in the recount, or a manual tabulation of printed reports from early voting, election day, mail-in, and provisional ballot canvasses. Under this provision, printed reports from precinct tabulators and high-speed scanners, if available, are examined manually and tabulated. And finally, any recount method approved by the state administrator. This bill would clarify that candidates must request either a full or partial recount of votes. Additionally, it requires local boards of elections to maintain standards for scanning and storing internet-delivered ballots. Specifically, they would maintain the original ballot source documents for any ballot requiring manual duplication, keep each sheet batched with the duplicate ballots that were scanned, and rely only on original source documents in a manual recount. To make sure the certification of our election results goes smoothly, this change to recount procedures establish a process with a clear framework for local boards of elections to follow. There is an amendment to this bill that clarifies that in the case of a manual recount, the voter verifiable paper ballot, not the copy, shall be counted, and for automated recounts, both the copy and the original must be examined by the local board of elections. If the copy and original agree, the copy may be used in the automated recount. If the two disagree, the local board must count the original ballot that accurately reflects the voter's intent. And with that, I'll urge a favorable report for HB 371.
Thank you. Any questions for Delegate Grossman? Okay, thank you very much. That concludes the hearing on House Bill 371. Delegate Chi, thank you for waiting patiently. House Bill 401, and you have Kevin Canale and Director Higgs. You want to come up?
Good afternoon, Madam Chair and the members of the Ways and Means Committee. For the record, I'm Delegate Lily Chi here to present HB 401. HB 401 seeks to fix a simple problem, or in the preferred language of the Ways and Means Committee, a loophole, by making sure that if a tax exempt property ends up generating rental income from that property, then such income must be reported to SDAT, the State Department of Assessment and Taxation. Currently, state law allows certain properties to be exempt from property tax if they are government-owned, charitable, religious, or educational. But in some cases, such properties are being rented out for income. And because there's no requirement for reporting to SDAT, many don't. Such property tax is assessed by SDAT, but collected by local counties. So counties can decide if they want to go ahead and collect the revenue that's being assessed. So it's important that SDAT is able to do its job. This bill simply requires such rental income to be reported to SDAT within 30 days if a rental property enters into a lease agreement for income. And if the property's lease is less than 1 year, that's exempt from the reporting requirement. As you can see, HB 401 is a simple change that would give ASTED more accurate data to do its job and to capture what should have been the income for the revenue for local counties. So with that, I urge a favorable report. Thank you very much.
Good afternoon, Madam Chair and members of the committee. For the record, my name is Michael Higgs, and I am the Director of the Maryland State Department of Assessments and Taxation. House Bill 401 would require properties that are exempt from real property tax to report any rental income to the department to be assessed for the value added. Currently, property tax exemptions are granted for properties for very limited uses as outlined in Chapter 7, Subtitle 2 of the property tax article. Property that generates rental income is not recognized under current statute as exempt property. However, the department generally does not conduct real property assessments for properties that are exempt from taxation. Because of this, exempt properties can construct anything from cell phone antennas to a restaurant and enter into long-term leases without paying any property taxes on the added value. By requiring exempt properties to report value-added rental activities, House Bill 401 would help local jurisdictions capture missing revenues by making the department aware of non-exempt properties that are subject to taxation. Accordingly, the department respectfully requests a favorable report on House Bill 401. And as a side note, we note that it is easier than ever to appeal your property assessment if you so wish. Thank you.
Good afternoon, Madam Chair and members of the committee. Kevin Canale here on behalf of the Maryland Association of Counties in support of House Bill 401. This is a really good bill. This is about taxpayer fairness. We know that there are a lot of properties out there that are generally exempt, but they do have income coming in, and therefore they should not be exempt for at least that portion of the property. You have my written testimony. I will just note that this is not a concept that's new to Maryland. Indeed, most personal property tax exemptions are based on equipment and machinery's use rather than ownership. And the federal tax laws also cover this as well, where even though a lot of entities are generally exempt from taxation, non-related business income is taxable. So this is fairness. This is not a concept that's new. Common sense bill. We'd urge a favorable report.
Thank you. Questions, Delegate Feldmark.
Thank you, Madam Chair. Thank you for this bill. I think I appreciate the intent, definitely. I guess I'm looking for clarification on the non-related revenue. And I want to make sure, are we only talking non-related revenue? And that I see nodding. So the example that came to my mind first is an affordable housing organization, right? Which may charge rent for the folks they are serving. That is revenue. It is related to the nonprofit activity. So would that continue to be exempt, or can you speak to that, please?
I cannot. I'm sorry. That's a question for one of my real property guys. They're going to have to get into depth on that one. What I can tell you is that the intent of the bill was to take an entire property that's tax exempt. And if you're using a portion of that property for a non-tax exempt use, then that portion of the property is no longer exempt and now needs to be assessed and taxed. It is not intended for the type of use you're talking about, and I don't think that would be caught up in it, but I don't want to be wrong and say it. Sorry.
I think from our perspective, from MACO's perspective, we'd be perfectly fine with an amendment to make that clear. I think another good example is somebody has a tax exempt property, but they own a parking lot, and they have leased that parking lot out to someone, and they're generating revenue that, again, is not related to the purpose of their exemption. So I think that's what the bill is really trying to capture.
Delegate Hornberger.
Two anecdote questions because, I've had some major concerns. Many of our churches host groups like Narcotics Anonymous, for example. They make very nominal donations to said churches. It's outside of their core as a church. So are they having to report because they're using the entirety of the space? As we know, churches are very infrequently used. They're only used on maybe 2, 3, 5 times a week. Would they need to report this?
Again, from a county government perspective, we'd be very amenable to amendments to clarify that this is really just about other pieces of the property that are income generating. So cell phone towers, parking lots, things of that nature. That's my understanding of the intent, and we would be more than happy to help draft amendments to make that clear.
Yeah, the statute lists value-added rental activities, and really that's what it's for. And a nominal recouping of costs is not a value-added rental activity. So I doubt that that would be applicable in this situation.
Okay, then the second one would be many of our fire halls use their hall space to rent for community events. And the community, whoever's the purveyor, whether it's a wedding or, you know, a fundraiser, what have you, they use the space temporarily 4 or 5 hours. And then they make some donation to the either Veterans Hall or the Fire Hall, et cetera. Would that also fall under the auspice of this bill?
I don't think that's the intent of this bill. I think it, first of all, it makes it clear that if its lease agreement is under 1 year, it's exempt anyway.
Okay.
And also it's more for those who are actually generating profit on the side when they are tax exempt.
Okay, thank you. And I have to step out. Thank you.
Delegate Mirabel North.
Thank you, Madam Chair. And thank you, Delegate Chief, for bringing this bill. Are there other states that do this? Delaware was the first of its kind in terms of bringing this tool.
Certainly, there are other states that do this. I haven't set out to conduct a survey, but just in attending conferences and talking to people in the industry, that this is not the first time that they've talked about an exempt use versus an exempt property, and delineating the difference like that.
Thank you.
Delegate Miller, then Delegate Henson.
Thank you, Madam Chair. So in the fiscal notes, the analysis does say that educational and government owned are included in this as well. So how would it affect schools?
Again, I think that if you had a lease agreement for more than 1 year, you know, I think that it's an open question, but if a school, I'm trying to think of a scenario in which this would apply. I think it would be difficult to envision one. I just don't think there are many schools that have adjacent pieces of property or even the same property that they're using to generate, you know, other sources of income with a cell phone tower or a parking lot. I'm for more than a year. I guess that would be the question.
Well, yeah, usually when you put a cell phone tower up, it's
Well,
for a
right,
long time.
right.
so-
In which case the department would assess that plot of land that on which the antenna, the cell phone tower sits, and would need to collect property taxes on that
from our schools.
from the county.
I'm happy to follow up with you offline. To
Yeah,
clarify.
I wanna
Yeah.
know how
I
that
don't,
works
I
with
don't
the
think that's the case.
Okay, we'll get the
They
experts
don't
involved.
usually pay the taxes, so that's why I'm very
Right.
confused about how that
I
would
don't
work
think
with
this would apply.
educational.
I'm not sure why the fiscal note references that, but I can't see this applying to schools.
Okay, and government owned, and then I
Right.
would want to know the impact on our farms.
Absolutely. Sure.
Thank you.
Thank you, Madam Chair, and thank you to the sponsor for bringing the bill. I guess my question is why? We have asked our nonprofits to do more with less, and when they do get creative ways to find sustainable methods of income for them so that they can continue to provide the critical missions that they do in our communities, I guess I just don't understand the philosophy of why we would penalize them for that by going back with an assessment and then taxing them on that property, when perhaps it's a way for them to be able to be more self-reliant.
I think the whole premise of this bill is the assumption that when the government decides that this piece of property should be used for nonprofit purposes, it should be used for nonprofit purposes, not for income generation purposes. That's what we're talking about.
Thank you. I guess my question is, a nonprofit's purpose has to be supported by income. It has to have the adequate resources to maintain staff, to maintain whatever sort of products support what they're doing. Let's say it's a food pantry or something. You have to be able to meet your operating costs. And if they're using these sort of creative ways to meet their operating costs, then isn't that providing the mission that we ask our nonprofits to do?
Yes, I understand your concern and it's a legitimate concern, but if in the course of doing that, they are getting too creative and essentially turning themselves into a for-profit entity on the side, then that is what we're talking about. Then that property should have been taxed.
Is there anything in the bill that kind of narrows the scope so that you would only capture that? Because what I'm thinking about is you have a church we have the, what is it called? Yingbies, Yes in God's Backyard. And so our churches now are getting more creative with being affordable housing providers, service providers, transitional housing, all sorts of things that they're able to use the property for that they have that may be income generating, but not necessarily a profit. It may cover the cost of providing these additional services. So technically an income, but not a profit. So I guess I'm trying to figure out if the bill could be tailored in a way that those sort of purposes would be thwarted.
I assume the intent of the estate's request for this bill is so that we capture the income that is in addition to the nonprofit mission. In that case, okay. So if they are in the normal course of conducting business, they have to charge a fee for service or something to cover the cost. That is part of their operating cost, right? That needs to be covered. But if they are entering into a side lease agreement with another party to generate income when they have been categorized as tax exempt, then that's a different story.
I think I understand your reply, and I think I disagree with the philosophy. I think that our nonprofits are being asked to do more with less, and the services they provide are very critical. And I think that penalizing them for being creative and being self-reliant is, I disagree with the premise, but I thank you for the answer. Thank you, Madam Chair.
Thank you. Any further questions? Okay, thank you very much. That concludes the hearing on House Bill 401. Delegate Chi, House Bill 257, and Jackson Taylor, Nikki Tyree, and there is one individual that is testifying virtually.
Thank you, Madam Chair, and good afternoon again, members of the Ways and Means Committee. For the record, I'm Delegate Lily Chi here to present HB 257. HB 257 simply aligns the party registration deadline with the in-person voter registration deadline. That's it. That's all it does. In practical terms, it means we would allow an unaffiliated voter to affiliate with a party and vote that same day at an early voting center, which is the same as an unregistered voter during a primary election, which in Maryland is closed. This small change will encourage voting in our closed primary elections and make our election system more equitable, inclusive, and democratic. It is important to note that this bill will not create an open primary system in Maryland because it will not allow those who are already affiliated with a major party to change their party affiliation during the specified time period, which is early voting. The Maryland State Board of Elections has confirmed that this change is administratively feasible and they can do that with their current resources pretty much. So why is this change necessary? First, our current system disenfranchises a large and fast-growing number of Marylanders. Today, close to 900,000 Marylanders are registered voters, but who have chosen to be unaffiliated with a party. Almost the entire size of the Prince George's County. That is how big that population is. Unaffiliated voters are also among the fastest growing in our state, with 35% of new voters last year choosing to be unaffiliated. So just about when these voters go to the primary election, and many of them don't, but if they do, the only thing that shows up on their ballot oftentimes is the school board election, which is nonpartisan. Just about every other election requires some kind of party affiliation. Second, our current system does not reflect our values as a state of diversity and inclusion. We are a minority state now, but you wouldn't know if you just look at the Democratic or Republican primary voters. In comparison, unaffiliated voters are far more diverse in age, culture, and socioeconomic status. Many are first-time voters coming of age as young voters, new citizens, and voters from a state with open primaries, which we don't need to look far to find one, which is like Virginia. These are the very people we are disenfranchising in our closed primary system. And third, our current system is also confusing and arbitrary. Currently, party affiliation deadline is 3 weeks before the election day. But there are two exceptions. One is during early voting, we still allow people who have never registered to just show up in person, register, pick a party, and vote immediately, that party ballot. And two, on the election day, we now have something called the same-day voter registration. A voter can go to the poll and register and pick a party and vote that same day. So why not allow the same thing for early voting, at least for the unaffiliated voters? I know some people will argue and say, well, look, primary elections are for party nominations. If people want to vote in primary elections, they should just go ahead and register as a party. The problem with that argument is multifold. First of all, is the assumption that all voters are familiar with our election system, which is not common. In fact, majority of the states do not have closed the primary elections. Only 14 states in this country do. And the second, not all elections are the same. Primary elections in Maryland are so much more important than general elections for many reasons. And so by disenfranchising the independent voters, we are essentially rewarding hyperpartisanship and locking out a lot of people in the middle. And the third and the most important point I want to make here is, regardless of which election we are talking about, primary or general, all elections in Maryland are funded by taxpayers, whether they can vote or not. It is our responsibility to make sure we make our election system as inclusive and accessible as possible. I want to point out that there is an amendment that committee should have received, which is to cross out the word provisional. In other words, if an election judge on an early voting day decides that resident is a resident of that particular county, then the election judge will then issue that voter a party ballot by request instead of a provisional ballot. And that's the only change. It was a mistake in drafting here. So in the final analysis, this bill is about equity and affects all races, ages, and socioeconomic backgrounds. And with that, I urge a favorable report. Thank you.
Good afternoon, Chair Atterbury and other members of the Ways and Means Committee. I am Jackson Taylor, and I'm an 18-year-old student and registered voter for Montgomery County. I will give a little bit of a warning that I'm going to repeat some of the things she said early on, but when I got my provisional license a year ago, I also got the answer to the question of whether I would like to register to vote and which party I would register my affiliation with. At that moment, I had a choice to make, and because I was split on this crucial decision, I decided to do the same thing my parents did, and I chose the option that said independent. I, along with just over 825,000 Marylanders registered to vote, cannot vote in the primaries now because of this decision. Many people around me consider this ironic, being that I am the same student that pushes those people to register to vote and work at polls on voting days. Of course, I do all this just to not to be able to vote at those same polls I am working at. And this is one of the many reasons why I'm here speaking to you on this today. The other important reason is the fact that this is an important bill for the state as a whole, but especially the youth voters within it. Because within this nation and state, two major factors continue to increase. One is a lack of voter turnout amongst youth voters, which the national data from elections done in 2022 found that only 23% of those ages 18 to 29 and able to vote did. And the other important statistic is that 2 out of 5 youth voters identified as independent. So with these factors in mind, you can see how allowing independents a chance to make the switch at the primaries can help out all voters, but especially the youth voters in the state. It's for these reasons that I ask for a favorable report on HB 257 to allow the increasingly independent youth like myself a chance to play a role in this crucial part of our election process. Thank you.
Thank you, Madam Chair.
Atterbury and Vice Chair Wilkins, and a special thank you to Delegate Chief for bringing forth this bill. You all have the League's written testimony, but for the record, I'm Nikki Tyree, Executive Director for the League of Women Voters of Maryland. And this is a very common sense bill for us. This is something that frankly was probably overlooked in the original drafting of how our primary and elections work. The truth of it is that younger voters, new citizens, and those who are just now becoming acquainted with our elections process have been locked out of primary voting because they are not affiliated. More and more, we're seeing younger voters who are disillusioned with our system and they're apathetic to both parties. New citizens, as Delegate Chi noted, are not up to date with how we run this, and it is very foreign to them. Passing this bill would allow all voters in Maryland to be enfranchised, and it just makes sense. We urge a favorable report. Thank you.
Thank you. And we do have, is Jason Maxstein with us? No, okay. So are there any questions from the committee? Delegate Griffith.
Thank you, Madam Chair, and thank you for bringing this bill. Just a quick question. Why would we only extend this to independents and not to party affiliated individuals to give them the same ability to switch parties or change affiliation?
That would essentially make an open primary. And if you want to offer an amendment, if the committee thinks that's a better idea, I'm not opposed to that.
Thank you.
Any further questions? Okay, thank you very much, Delegate Chi. And that concludes the testimony on House Bill 257. Delegate Guyton, House Bill 331. And I have Nikki Tree, and we have two people virtually here, Louisa Dugan and Jakaya Johnson. And I should say, committee, if you do have any questions for the State Board of Elections, Director Jared Marinus is with us. And if you are testifying virtually, please turn off your live stream so there's no echo. Whenever you're ready, Delegate Guyton.
Thank you so much. It's lovely to see all of you. Thank you, Madam Chair, Madam Vice Chair. And today, for the record, Delegate Michelle Guyton from Baltimore County, District 42B. And I have always had a heart for service, and I have always had a brain full of very strong opinions. If you know me, you know that to be true. No one's going to argue. And yet I could not run for office or did not see my way clear to running for office until I was 50 years old. Okay. The reason for that is that I had 3 children who were complicated. Probably if they'd been uncomplicated, I still would have waited until they were older. But for my mothering and my parenting, it was necessary to be clear of enough child rearing that I didn't have to worry about whether I could find childcare or afford childcare for them as I was running for office. That is one reason I am bringing this bill to you. I respectfully submit House Bill 331 for your consideration, and this bill codifies a 2019 guidance letter from the State Board of Elections that authorizes childcare expenses as an appropriate use for campaign funds. Now, most people don't know this. Even though the Board of Elections did say in a letter in 2019 that this was possible, we've done some research and found that only $522 since that time has actually been filed for childcare expenses, most likely from the person that requested that letter, although I don't know that for certain. So the purpose of this bill is to encourage and support wider and more inclusive participation in our political system. Currently, parents of young children and dependents with significant disabilities, are disincentivized from running and serving in elected office. And the importance of codification, which is something we might discuss here, really cannot be overstated. It's necessary to protect this ruling by codifying it in state law to provide awareness, for instance, but also to provide a peace of mind and consistency, both for political changes and for people who may run for office. While this is considered an acceptable way of using our campaign funds, but be worried always that it might change during their stint in office. So in addition, just so you know, I've also submitted an amendment. Delegate Polakovich Carr, who I know is in another committee because I just ran into her and she's not here today, did put in a very similar bill a few years ago. Hers was a bit broader than what I'm introducing to you today. I spoke with her about that and I really tried to narrow this bill to things that were not as controversial as some of the other things in her bill. But if you do want to expand this bill, you have an amendment that I've sent to the committee already to also clarify that adult dependents with disabilities who need care may also be considered and covered under this authorization. And I will leave that piece in your hands, but I would also support that. So I request a favorable report on House Bill 331 and thank you for your time today.
Thank you, Madam Chairwoman. Again, Nikki Tyree for the League of Women Voters of Maryland. And thank you to Delegate Guyton for putting forth this bill. The truth of it is that democracy should be representative to those that we see around us. And the League is fully supportive of that theory as well as in practice. If some of you were lucky enough to tune in to EEE last week, you would have seen me testifying on 4 bills and you would have seen a 3-year-old on my lap for one of those. The truth is that Maryland rates within the top 10 states for single parent households. And while this bill does not specifically speak to single parent households, this is who we would be able to elect. And we deserve to have people who represent us and know our struggles. Mothers and fathers should not have to pick between participating in democracy and taking care of their children. This is a very simple bill and we urge a favorable report. Thank you so much.
Thank you. And Ms. Tyree, I'll just say thank you for your comments as a single parent of 3 children. Do we have Louisa Dugan or Jakaya Johnson? Okay. Ms. Dugan, go ahead, please.
Hi, how are you? My name is Louisa Dugan, and I'm submitting testimony on behalf of Vote Mama Foundation in strong support of House Bill 331. Childcare obligations are one of the major factors families consider when weighing their decision to run for office. In many states, it costs more to send an infant to childcare than to complete a mortgage payment. This is not an expense working families can take on, especially when campaigning for office. Vote Mama Foundation is the only organization working to expand and codify the use of campaign funds for childcare in all 50 states. Having young children should never deter any parent from considering a run for office. We believe being a caregiver is a resume builder and that we need folks in office representing the needs of everyday families. By making this one simple change, we can support young families and their need for safe and affordable care. In 2018, the Federal Election Commission approved federal candidates' option to spend campaign funds on childcare through a unanimous bipartisan vote. This paved the way for other federal candidates to do so as well. Subsequently, 30 states, both Democratic and Republican, have brought their state statutes in line with federal regulations. States like Arkansas, California, Washington, and West Virginia all allow for candidates to use their campaign dollars on caregiver expenses. Currently, under Maryland state law, state and local candidates are allowed to use their campaign funds on childcare expenses through an ethics ruling that was published in 2019. This bill would codify that ruling. And doing so, the Maryland legislature has the opportunity to send a clear message to all candidates up and down the ballot in Maryland that the use of campaign money on childcare expenses is explicitly allowed and should be normalized. This legislation is a bipartisan initiative for moms and dads alike. As with any other campaign finance, this bill creates an option for use and is not a mandate. Candidates do not have to use their campaign funds on caregiving expenses if they do not want to. Even better, this common sense solution is at no cost to taxpayers or state governments. I'm thrilled to share that just last month, Vote Mama Foundation released a groundbreaking report on the impact and usage of campaign funds for childcare. And our research revealed that since 2018, campaign funds for childcare spending has increased by over 600% for federal candidates and by over 2,000% by state and local candidates. The majority of federal funds were spent by women. At the federal level, 46% of funds were spent by candidates of color. And at the state and local level, 70% of funds were spent by candidates of color. Thank you for your time and consideration. I respectfully ask the House Ways and Means Committee to support House Bill 331 and vote it out of committee, and I'm available for any questions.
Thank you. Jakaya Johnson, please.
Good afternoon, Madam Chair and members of the committee. My name is Jakia Johnson, and I am the Executive Director of Reproductive Justice Maryland, and I strongly urge a favorable report of House Bill 331. Reproductive Justice Maryland is dedicated to advancing the rights and well-being of individuals and families, and we believe that this bill is a crucial step towards fostering inclusivity and equity in our political processes. Parenthood, particularly for mothers, is a significant barrier to political participation. And very often women are told to wait until their children are older or no longer in need of childcare before they consider running for office. But this expectation perpetuates gender disparities in political representation and also undermines the principles of equity and fairness that are really fundamental to our democracy. So when we consider the broader landscape of political representation, it's clear that women, and particularly mothers, continue to face obstacles. Despite making up over half the population, women remain severely underrepresented in positions of political power. Across the country, women make up about 31% of state legislatures. And at the current rate of progress, it would take 118 years to achieve gender parity in our political landscape. HB 331 represents a crucial recognition of the intersectionality between parenthood and political engagement. And by expanding the definition of expenditure to include childcare expenses, this bill will dismantle one of the most significant barriers to political participation for parents. So we urge you to vote in favor of HB 331 to ensure that all individuals, regardless of their caregiving responsibilities, have the opportunities to really participate meaningfully in our democratic processes. Thank you.
Thank you. Questions? I'll start with Madam Vice Chair.
Thank you so much, Madam Chair. Thank you, Delegate, for bringing this bill. I really, as you know, like this bill a lot. I see I am actually a co-sponsor here. Thank you. I think it's a great bill. But and my question might be for Mr. Demarinis. I just wanted to better understand, because we always have to think about what guardrails or how this could go wrong, all of those different scenarios. And I wanted to better understand. So sometimes childcare is very informal. It can be your niece, it can be your nephew, your sister, whoever. I was curious, since this is something that potentially can already be used, if there were any restrictions. I'm not saying that there should be, but how we deal with that currently. So someone's campaign finance account paying out their sister, for example, how that would currently work, and how you have been implementing it currently.
Oh, sure. Great question. So Jared Demarinis, State Administrator of Elections, for the record. So currently, it would be treated as any sort of payment to any vendor or any staff member or any person that you employ for that purpose. So if you hire your sister, niece, nephew, they would go down on campaign finance report for that transaction, for that amount. And it would be an other expense with the comments like babysitting services. The only tie-in would be that it has to be electorally related. So, for example, you couldn't go and use this, you couldn't use campaign funds to say, have a date night or go to the movies or something to that effect. You would have to say, it would be tied to, like, I need a daycare to go to a campaign event. I need a daycare to go to a fundraiser, or so there would have to be at least some sort of nexus there to it. And if we questioned that expense, or if there was any sort of questions about it, you would have at least some sort of documentation to prove that it did occur. So that it would be like, oh, here's the fundraising solicitation that I showed up at this person's house. This is why it was, from 5 to 7. This was, I got babysitting from 4 to 8, something to that nature there. And we would be like, okay, that would be acceptable moving forward. But it still would have to be tied to electoral purposes.
Okay, that makes a lot of sense. Just a quick follow-up. So usually when we are reimbursing or making expenses, we also get receipts
for campaign finance. So little Susie, who's helping to babysit, who's 15 years old, we might need to create a mechanism for her to be able to provide a receipt and just a paper trail and.
Exactly right. Yeah, I mean, it's one of those things, right? If it's little Susie, that's a 15-year-old, the campaign might not want to do that because it's going to go on the public document and be out there. It's a little bit different than just hiring a regular babysitter because it is going to be disclosed and people will be looking at it and seeing what's going on with your expenses.
Delegate Hartman.
Thank you, Madam Chair, and just looking for further clarity. So, getting elected is just part of the problem, and after, I shouldn't say problem, a lot of the time, but 4 years after that there's a lot of time to stay elected. We attend volunteer fire banquets and things like that. So you're saying this would be an ongoing expense from campaigning all the way through the 4 years as you attend those events. Those events are to help you get reelected, get out there in the community, recognition and so forth. So that'd be a recurring expense for those 4.5, 5 years, whatever, from campaign throughout.
Yes, I mean, right now it's, once it's electorally, if you have electoral purpose with, your mission or why you have to employ a daycare or a babysitter, then, for that, it meets the statutory requirements of the law and it's permissible expense. And, so it doesn't matter if it's, year one or if it's in the campaign year or it's, you're going to a firehouse grand opening or anything like that to be more visible in the community or any event like that, as long as there's some sort of nexus relationship, then it's perfectly legitimate.
And then the other question, you had mentioned adding if it was taking care of elder parents or something of that nature as an amendment.
Hi, thank you. Thanks for that question. So the amendment doesn't say elder parents. It says dependents who have significant disabilities who need specialized care.
So
some of our children, for instance, may, even though they're older than the average child who would need care, may need care much longer. I think and that was the intent of that amendment.
So if parents were dependent, that's not included.
The definition of the word dependent, you know what, that's a great question. And I'm not sure legally I have the answer. I think that might be something that the subcommittee could consider, if and how much they wanted to open that up. Again, all of that I would consider friendly amendments, anything that gets people in.
Clarification, having, taking care of two parents,
Sure.
having 24-hour care for them.
Absolutely.
Just thinking, okay, now, so just looking for clarity. I'm just concerned as to how much abuse something like this we could be opening our campaign accounts up to. So that's why I was asking. Thank you.
Delegate Miller.
Thank you, Madam Chair. My only question is, so if you do take the amendment, would you be amenable to adding co-sponsors? Because I did miss this one. Because there's no way I could have done this.
We allow co-sponsors of committee members if there are amendments that have to be, because I would want to be on it. So
there we go.
Thank you.
Any further questions for this committee? Okay, Delegate Guyton, I really appreciate this bill. When I ran for office, I had one that I was about to give birth to and 2 in diapers. And the amount of childcare was, from then to now, has been astronomical. And I pay my family with love. But I've paid childcare centers, aftercare, and a long-term sitter that has known me since my oldest, who's now 12, at the time was 1. I mean, just if I added it up, I'd probably have a heart attack. So appreciate this legislation being proposed. So thank you all very much.
Thank you for those comments. Thank you, everyone.
And that concludes the testimony on House Bill 331. Just going to go out of order and call House Bill 287 because we asked Delegate Charkoudian to hop down because at the time Delegate Plakovich Carr was in a hearing. She's returned, but I'll call you next. Thanks. Yes, please.
Oh, there we go. You do hit the button in here. Some committees you do, some you don't. Gets very confusing. Good afternoon, Madam Chair, Madam Vice Chair, colleagues. For the record, Delegate Lori Charcutean asking for a favorable report on House Bill 287. So this is sort of part of the same bill that I had last week, which is related to the homeowners tax credit, tax credits that's designed to keep people in their homes as property values are going up. If you recall last week when we talked about this, there's the homeowner tax credit and then there's the renter tax credit that matches the homeowner tax credit mostly. And after you hopefully pass this bill fully, the idea being that renters are also paying property taxes, and when property taxes go up, rents go up. And so low-income renters who would otherwise qualify for the homeowner tax credit ought to also have access to that tax credit. So it's related to keeping people in their homes, especially in areas where property values are rising quickly. Somehow, though, when the renter's version of the tax credit was created, the rules were created differently. So the rules are, here's what counts and here's what doesn't count as income. And then that's used to calculate whether someone's eligible for the tax credit. And then the certain percentage, right now it's the 300,000. My bill last week increased that of the property value is credited. And so what this bill does is it just tries to create equity between renters and homeowners. For some reason, when the renter's tax credit was created, the cash value of any qualified retirement plan is determined to be held against renters in their income, while for homeowners, it's not held against them. And so the idea behind this bill is just to match homeowners and renters. If we're going to have equity in both having access, they ought to have the same rules. I suspect it was an oversight. I'm not actually sure how it happened. I don't know if anyone here knows the history of that, but this bill is attempting to fix that. I have a panel here who will say more, including SDAT, who supports this bill. But before they speak, I do want to have a chance to speak to the MACO proposed amendment. And I think they'll be up here shortly, but their amendment appears to be that if the state does this for the state tax credit, that it ought to be optional for the local tax credit. And what I would suggest is I do think it's problematic for us to make equity between renters and homeowners optional. And so I think that if this committee wants to move forward with the bill as it's written, which is that the rules are going to be the same for renters and homeowners at the state level, and if the locals choose to match it, then it would be the same in that context. If you want to go with the MACO proposal, my suggestion would be that what would be optional is either to count retirement or not, but that the rule would have to be the same for renters and homeowners. I think it's really important that at the state level and at the local level, the rules are the same. So if something's going to be optional at the local level, it ought to be optional but equivalent for renters and homeowners. And I hope that makes sense. And after the panel speaks, I'm happy to take any questions. Thank you. Check to go.
Good afternoon, Madam Chair, members of the committee. My name is Michael Higgs, and I am the Director of the Maryland Department of Assessments and Taxation. House Bill 287 would exclude the value of retirement accounts from the department's definition of assets for the purpose of qualifying for the renter's tax credit. Renter's tax credit provides vital economic assistance for residents living below the federal poverty line to offset the cost of property taxes, which are included in their monthly rent bill. The department currently does not have a consistent definition for how assets are considered for the purposes of the various tax credit programs it provides. Because the renter's tax credit considers the cash value of qualified retirement accounts to be considered assets, renters are thus disincentivized from saving for retirement. Furthermore, differing definitions of assets create confusion and have an adverse impact on administrative efficiency. House Bill 287 would exclude the cash value of retirement accounts from the department's definition of assets for the renter's tax credit program. This bill would expand the renter's tax credit program to include more residents in need, incentivize retirement saving, and secure financial stability for communities in need of short and long-term financial assistance. Accordingly, the department respectfully requests a favorable report on House Bill 287. Thank you.
Good afternoon, Madam Chair, Madam Vice Chair, and members of the committee. My name is Zoe Gallagher, and I'm the Policy Associate at Economic Action Maryland, formerly the Maryland Consumer Rights Coalition, a people-centered movement to expand economic rights, housing justice, community reinvestment in Maryland. As a part of our work, Economic Action's Securing Older Adult Resources program works with older adults to assist them in applying for benefits like the Renter's Tax Credit program. I'm here today to urge you to vote favorably towards House Bill 287, and I'd also like to thank Delegate Charkoudian for bringing this bill to the committee. To our organization, excluding retirement savings from total assets to determine eligibility is just common sense. These are already low-income people that need to meet these income-based requirements in order to be eligible for the tax credit in the first place. So including retirement savings in total assets undermines the purpose of these credits to ensure that low-income families and older adults can maintain financial stability in the face of rising property taxes and rent. For older adults, especially those living on fixed incomes, every dollar counts. Many have worked hard to save for their retirement, and it's unjust to consider these savings as regular assets. For low-income families, this bill could mean the difference between just getting by and having a little extra to invest in their futures. One of our clients, a 70-year-old widow living in Baltimore City, lives modestly on her late husband's pension and her own retirement savings. Despite having these savings, she often struggles to make ends meet due to the high cost of rent and medical expenses. Unfortunately, the cash value for a retirement plan pushed her just above the cutoff limit for the renter's tax credit, which has led her to cut back on necessities in order to pay for rent. It is already incredibly difficult for low-income families to save for retirement, as the cost of living has risen dramatically over the past few years. As the older adult population continues to rise, we need to ensure that we are taking measures to incentivize saving for retirement in low-income households. This bill improves the equity of these programs by recognizing that all individuals, regardless of economic situation, should have the opportunity to secure a dignified retirement. Thank you.
Madam Chair, Madam Vice Chair, members of the committee, my name is Matt Hill. I'm an attorney at the Public Justice Center. Public Justice Center advises or represents over 800 renter families each year and works with tenants to protect and expand their right to safe, habitable, and affordable housing. And we seek a favorable report. Excluding retirement savings from eligibility calculations for this tax credit will bring crucial economic relief to fixed income senior citizens. Such lower income seniors live under the constant pressure of limited incomes and rising housing costs. I know in the Baltimore metro area, we've seen rents increase 19% in the past 3 years. Social security checks have not gone up 19% in the past 3 years. And I will tell you that a number of our clients right now in rent court are senior citizens who cannot keep up with the rapidly rising rent inflation that we see across the state. By excluding retirement savings from this asset calculation, more seniors will be eligible to claim the tax credit and readily remain in their homes. And so we'd ask you for a favorable report.
Any questions from the committee? Okay, seeing none, thank you very much. That concludes the testimony on House Bill 287, House Bill 347, Delegate Plokovich-Carr. And I have a Liza Smith and Bernard Holloway.
I don't actually have a sponsor panel, but they're welcome to.
Okay.
Yeah. So good afternoon. For the record, I'm Delegate Julie Plokovich-Carr here to present House Bill 347. This is a bipartisan bill that I'm proud to have worked on with Delegate Griffith. The bill would ensure that the appointment process used to fill vacancies in the General Assembly is transparent and inclusive of the public. And I want to be upfront and say that this bill is not about any particular appointment that has happened in the past, and that every member of this body makes valuable contributions regardless of how they first arrived here. As you know, all vacancies in the Maryland General Assembly are filled by appointment by the governor with input by the local central committee. And in the past 10 years, there have been 63 legislative vacancies in Maryland. And nationwide, overall, we rank second amongst all states in terms of the total number of vacancies that have occurred in our legislature. This high number of appointments has strained public trust in the process. We see those concerns bubbling up in support for a different process for filling legislative vacancies, special elections. For those of you who support the idea of special elections, you should know that we will still need this bill, even if we and the voters pass special elections and do a constitutional amendment. And that's because the special elections bill that we are hearing in a few minutes does not provide for a special election 100% of the time. There would still be appointments being made under certain circumstances. And for members who prefer the current process and not having special elections, I'd say it's even more important that we take action to clean up the process and to ensure that both major political parties are held to the same standards. This bill will ensure a transparent appointment process with public engagement. It follows the best practices established in other states' laws. And some of the provisions of the bill are already included in one or both major political parties' current bylaws. So this bill would provide sufficient time for someone to apply for a vacancy, not just party insiders, provide the public with the opportunity to read submitted applications and watch the vetting process, prohibit secret voting by a central committee, prohibit self-dealing. A central committee member who applies for vacancy would be required to recuse themselves from the vote. And additionally, the Montgomery County and Prince George's County central committees would be required to translate vacancy information into Spanish. And that really is just to align with the existing requirements under the Federal Voting Rights Act for all the other elections that already take place in those two jurisdictions. So collectively, these reforms will boost public trust in the appointment process and ensure that all central committees across the state follow the same minimum standards. Thank you.
Thank you. Any questions for Delegate Plavkovich-Carr? Delegate Wu.
Thank you, Madam Chair. Delegate, I have a question. If the Central Committee didn't follow the rule, should they nullify or invalidate their nomination? Should there be mechanism there somehow?
You know, the bill doesn't speak to that specifically, but I have full faith that the central committees, if we pass this, would abide by the law. It's state law. So yeah.
Sure, thank you.
Any other questions? Okay, thank you, Delegate Plavkovich-Carr. If Liza Smith, Bernard Holloway, and Nikki Tyree could please come forward. Okay, no Bernard Holloway. Okay, whenever you're ready, you may begin, please.
My name is Lisa Smith. I'm a proud member of Montgomery County Central Committee. Today, I'm here to express my view and support this bill. HB 0347 addressed the flaws in Maryland appointment process for filling vacancy in the General Assembly. I just want to say that currently Montgomery County, we do follow these procedures, but it's voluntary. As a member of MCDCC, I have witnessed firsthand the importance of guidelines and transparency in the candidate selection process. Unlike other central committees, our committee has taken proactive steps to ensure democracy, but also to uphold transparency. HB 0347 align perfectly with our efforts to promote fair and in practice for each person to know when they're applying for a position that the public is informed and that it's done with accountability. It's worth noting that Republicans and Democrats support this bill, indicating a clear recognition that this reform is essential to a fair system across party lines. And we also believe that it's important for democracy. Thank you.
Thank you.
Thank you, Madam Chair Atterbury, Vice Chair Wilkins. Again, Nikki Tyree for the League of Women Voters of Maryland. I'm here to support HB 347. This is a very simple transparency bill for us. The central committees have done an excellent job in their appointments. However, we would like to see more transparency in the process, more public involvement. Short of special elections, this is the best way for democracy to win out and for the voters to feel enfranchised and engage in their civic responsibility. The league has requested a small amendment to the bill that on the Senate side, it was amenable, that there be a disclosure of central committee members who may know the candidate put before them. Very simple amendment. Thank you so much.
Thank you. Any questions, committee? Okay, seeing none. Thank you both very much for being here. That concludes the testimony on House Bill 347. Delegate Rosenberg, House Bill 333.
Thank you, Madam Chair and members of the Ways and Means Committee. Do not read the bill as introduced. Okay? I asked the AG for advice, was told that there were significant First Amendment concerns about the bill as introduced because it was largely because it would impose a penalty on purveyors of information, providers of information. We have significantly amended the bill, and that was emailed to you today. Hopefully you have it in front of you. It was not part of the, didn't get to you 2 days in advance, Friday, but hopefully you have it before you, and hopefully if this bill is referred to the Election Law Subcommittee, that is the document that we would request that you work from. But the goal of this bill remains the same as a significant amount of legislation that this committee has passed over the last several years, if not decades. That is to try and deal with misinformation that is part of, regrettably, part of the election process to a growing degree. And this bill is limited to this bill doesn't, let me put the negative first. This bill does not speak to misinformation about a candidate. That is far more subject to disagreement, interpretation, so on. This bill focuses on really the laws that we have passed regarding the election procedures, regarding voting rights, regarding voting results. It is explicitly limited in its scope. And the enforcement would no longer be, under the amended bill, would no longer be a penalty against the platform on which this information was disseminated. They would be informed. They would be expected first. First step is if they become aware of information on their site that violates their own terms, not ours, but information that violates their own terms, they would be expected to take it down to inform the state Board of Elections that there has been such a violation of their terms. There is no, in the amended bill, there is no penalty. We think that we have asked for a second letter from the AG's office. I have, but that request was made Sunday afternoon when I received the interlineated copy of the amended bill. So we do not have a response as yet. Obviously, I will share that with the committee as soon as it becomes available. SBE under the bill, the amended bill, instead of imposing a penalty, would ask that the corrective action be taken, request that the platform remove the disinformation. There would also be a new portal on the SBE site mandated by this law where citizens could could inform SBE and through this portal the public of violations under the already existing provisions of our law that speak to what is improper action and what is actionable misdemeanor, an actionable misdemeanor. Look at 12-601 in the election law in terms of what we over the years have tried to make a crime that reaches the level of a crime because it violates the very fundamental right to a fair election process, one that we have updated over the years, 12-601, and I would submit that the amended bill before us today is yet another important and needed step in that process. The bill would also clarify the definition of influence to make that clear, because that's an essential part. That phrase is an essential part of 12-601. And it is basically a dictionary definition. And that's the conservative way. That's not a liberal way to write our laws, because that's something very much that the conservative justices from Scalia onward have supported on the court. So that's what that part of the bill seeks to do, is to clarify what what constitutes influence, which is a predicate for several of our, or for basically for 12-601, an effort to influence people's actions and or the outcome of an election. So for all those reasons, I would request that the committee consider this bill as amended, and certainly open to further refinement. But given the bottom line here is that there are new ways, unfortunately, to provide misinformation about the election process. And let me repeat, we are not going after misinformation about individual candidates for office. This is misinformation. There's a specific provision in this law that was the result of literature that urged people to vote on November 10th, when November 8th was election day, that urged people, implied that you couldn't vote if you owed rent or if you owed BG&E. That was not illegal under existing law at the time that literature came out, close to election day in certain precincts, only in certain precincts. We amended 12-601 to make that a crime, to influence an individual's decision whether to vote. And I would strongly suggest to the committee that the growth of such literature, if I may put it as a neutral way, such literature, such misinformation on the internet merits, if not demands, our action now. Thank you very much.
Thank you. I'm going to ask Kevin Canale to come up because he is signed up as favorable as well.
Good afternoon, Madam Chair and members of the committee. Kevin Canale here on behalf of the Maryland Association of Counties in support of the bill. Understand that the bill is now not the bill and there'll be a new bill, but I think our testimony lends itself to both versions. Election disinformation, including lies about the voting process and election workers, disenfranchises voters and suppresses turnout. That's the bottom line. We need to do something to hold someone accountable, these social media giants, from allowing this information to be amplified over and over and over again and taking no action. It's pretty clear that we cannot rely on Congress to do much of anything. So if there's anything the state can do to crack down on this type of activity, we certainly would support that and support the delegate's bill and any amendments that he or the committee feels are necessary to put the bill in a posture that can move. So with that, we'd ask for a favorable report, and I'm happy to answer any questions.
Thank you. Any questions, committee? Okay, seeing none, thank you both very much. For the unfavorables, Caro Zabo, Ayo Kimathi, and then we have two that are virtual. So whenever you're ready for 2 minutes, please.
Thank you, Madam Chair, members of the committee. My name is Carl Zabo. I'm Vice President and General Counsel of NetChoice. I'm also a adjunct professor of internet law over at the George Mason Antonin Scalia Law School. Look, I've been a lifelong Maryland resident. Election interference, terrible. Unfortunately, this legislation that we are looking at right now actually has the effect of undermining confidence in our election, because essentially the government coming in and saying what can or cannot be said online, what can or cannot be said about elections. There are also a myriad of, even with the amended version, which I have in front of me, may not be the amended version, but there's still First Amendment problems. There's direct collisions with the right to speech. Looking at the definition of disinformation alone, you can look at essentially on line 8 and 9, where it says incorrect or misleading information. So let me give you an example of potential incorrect or misleading information depending on who the speaker is. So David Blair in Montgomery County challenged the outcome of the election, saying that he wanted a recount. Under this law, that will be election disinformation because you're now challenging the outcome of an election. And the same is true for Senator Brocken in Baltimore County executive election back in 2018. Statements on incorrect facts, incorrect, not malice, but incorrect, just you didn't know, is now an actionable item under this legislation. Now, we spent a whole 2 hours right now talking about how complex the voter registration, what you can vote if you're an independent, if you can vote in a primary. A lot of complex questions out there. You can't even ask those questions really, or make statements that are just incorrect. You didn't know, but they're incorrect. Last but not least, there's a name and shame component with this legislation. So the social media platforms are required to report it to the Board of Elections, who then makes those names available online. So even if you are a candidate or an individual who made a mistake, you are now essentially getting branded with a scarlet E for election denial. Really scary. So not ready for prime time. We ask an unfavorable ruling.
Thank you.
Thank you, Madam Chair and Board, for this opportunity to address this issue. Naked sedition. On the surface, this bill gives Jews who own and control social media, which is the largest platform for the sharing of information around the world.
Okay, sir, if you could just direct your comments to the bill, we'd appreciate that. We can't consider anything else, okay?
Okay, this is actually what I'm talking about. I'm supposed to have 2 minutes of unabridged time to say.
Well, it's not actually unabridged time. It's time to discuss the merits of what's in the bill and what's in the bill only. And we ask that you be respectful to everyone on the committee and anyone that's listening.
Right. So what I am saying is my perspective and my freedom of speech, which is being inhibited when I say the word Jew. No explanation has been given to where I was going with my explanation of why it's a problem. Brin, Page, Zuckerberg are Jews who control and own social media. So what I said was fair, honest, and can't be disputed. Yet I can't say it unabridged and finish my statement.
Okay.
Because right now,
Sir,
my freedom of speech is being inhibited.
I'm gonna give you one more opportunity to stick to the merits of the bill. One more opportunity, that's it. And you have 20 seconds.
My 20 seconds, what I will say is the merits of the bill is what I'm stating now. And my right to free speech right now is being inhibited by the state of Maryland because I can't state the truth for the record.
Thank you very much. Are there any questions from the committee? Delegate Henson.
Thank you, Madam Chair. My question is for Mr.
Zabo, but yeah,
Zabo.
don't worry, I'm too old to care, but thank you.
I apologize. We've we've had a couple of bills where I've been trying to figure out the distinction between online content and then in person. So if a person stood in the middle of a public square and shouted things that were misinformation, would the bill address that, or is it something different about when the content happens online?
Great question. So it would not address that. In fact, one of the things that this would not address is entities like 4chan, Truth Social. Many of the smaller mid-sized platforms are actually not covered by this. It's only once you achieve a certain scale are you even covered by this legislation. Now, with respect to the question about the public forum, that is an individual's right. Like they can essentially say statements that are patently false. I may not like them, you may not like them, but that is their constitutional right. We have a constitutional right not only in the US Constitution, but in the Maryland State Constitution for such things. There are such things as time, place, and manner restrictions, but this doesn't quite hit that. Maryland previously did try to do such actions like transparency in election ads, which even has a less protected level of First Amendment protection, and is ultimately lost at the Fourth Circuit when the Washington Post brought an action against it in Washington Post versus McManus. The First Amendment is a double-edged sword. It's horrible at sometimes, but it's great. And that's kind of the way it is. And if somebody wants to go out there and lie about the outcome of the election, that's unfortunately they're right. The concern I also have with this is I appreciate the intent. I don't think this bill is ready for prime time because the terms in it are so broadly written. Just the word disinformation is really in the eye of the beholder. And it's a really scary fact that such a word has become mercurial. But when even incorrect statements can now result in incredible harms, that's kind of scary.
Thank you for the response. Thank you, Madam Chair.
Thank you. Any further questions for either of these two individuals? Okay, thank you both for being here.
Thank you.
We do have 3 folks signed up that are here virtually. Margaret Durkin, Kahara Boender, and Kirsten DeSouza. So we'll see who pops in first. Okay. Ms. DeSouza, for 2 minutes when you're ready, please.
Thank you, Madam Chair and members of the committee. My name is Kirsten D'Souza, and I serve as the Coalition's Director for Chamber of Progress. We are a tech industry coalition committed to ensuring that all Americans benefit from technological innovation. For full transparency, our corporate partners do include companies like Meta and Google, but our policy at our organization is that our partners do not have a vote or veto over our positions or our advocacy. As stated by others, I have not seen the amended version of the bill, but I think our testimony will still speak to some of the issues that we do have with it. We're urging the committee to oppose this bill, which would undermine civic dialogue on social media, threaten user privacy, and raise troubling constitutional concerns. Unpleasant content, including misinformation, is one of the top reasons users and advertisers leave social media platforms. Accordingly, these platforms invest heavily in fostering reliable public conversations, particularly during election season. Platforms employ globe-spanning teams to review questionable content under their own terms of service, with escalating sanctions on users from warnings to permanent bans. The reporting requirements in this bill are so extensive, as mentioned. Account name along with time, date, and geolocation could lead to retrospective identification of users. This also runs counter to core privacy values of online data minimization. As mentioned, the government dictating content moderation decisions raises troubling precedent and constitutional concerns. As discussed, this bill would insert the government into these core editorial decisions and curatorial decisions, and in doing so, create a troubling constitutional precedent. So we do agree that this bill is not ready for prime time. We do ask that you oppose the bill. Thank you.
Thank you. Any questions from the committee? Okay, thank you very much. Bring in whoever is next. Ms. Boender, for 2 minutes, please.
Thank you, Madam Chair, members of the committee. I appreciate the opportunity to speak today. My name is Kara Boonder. I'm State Policy Director at the Computer and Communications Industry Association, also known as CCIA. CCIA is an international not-for-profit trade association representing a broad cross-section of communications and technology firms. I'd like to thank the sponsor for acknowledging that there needs to be some work done on this bill because unfortunately, while we are supportive of the goal of the legislation, we are not in support of the bill in its form today. I'm going to echo a couple of other concerns that have already been raised today, and I know I've submitted written comments, so I'll try to keep those at a minimum during this time. We do think that there are several provisions that warrant additional clarification in order to facilitate compliance. We're also concerned, similar to previous witnesses, about the thresholds for what constitutes a large social media platform. As mentioned, the revenue and user-based limitations specified in the bill are likely to not encompass other services on which election mis- and disinformation may appear, such as Truth Social or Parler, which is rumored to relaunch this year. We also have some concerns about the reporting requirements regarding election disinformation. The development of those reports are extremely labor intensive. Of course, it's supporting a very important goal, but we'd also recommend that the reporting requirement be limited to a time frame that's consistent and aligned with the state board's ability to respond to those reports from the social media platforms, and also to offset the time and labor necessary to produce such detailed reports. Again, we thank the sponsor for taking a thoughtful approach to addressing this important issue, and we look forward to working with the sponsor on potential amendments to this language. Thank you. I appreciate your time and welcome any questions.
Thank you. Are there any questions for this witness from the committee? Okay, seeing none, thank you very much.
Thank you.
And last, Margaret Durkin, please, for 2 minutes.
Good afternoon, Chair Atterbury and members of the committee. My name is Margaret Durkin, and I'm the Mid-Atlantic Executive Director for TechNet, a technology trade association. Online services enable freedom of expression, and our members are committed to creating safe and appropriate environments for users online. TechNet would like to thank the sponsor for his amendments, which removed the fine structure as well as the liability. But while the intent of House Bill 333 is laudable, TechNet remains opposed to the bill due to some lingering concerns. We maintain concern about the definition of large social media platform, as well as the subjective nature of the definitions of election disinformation, as well as influence. Most notably in the bill, there is now a 2 business day turnaround time for platforms to decipher whether or not any information is in fact election disinformation. While that change was made from 48 hours to 2 business days, that is still not enough time. Our platforms use both artificial and human intelligence to remove content and need more time to decipher whether or not that information is indeed false election information. Furthermore, as prior speakers noted, there is a data sharing and privacy issue with this bill. Some of the requirements in the bill require that platforms disclose the audience of the communication, as well as name and account for those responsible of the alleged disinformation, which we believe is a privacy violation. And for the reasons stated above, TechNet is opposed to this bill. Happy to take any questions. Thank you.
Thank you very much. Any questions from the committee? Okay, seeing none, thank you very much. And that concludes the testimony on House Bill 333. House Bill 412, Delegate Foley. And I'm not sure if you have a panel, but I do have some folks I can call up that are in favor, or you can come by yourself. It's up to you.
The folks who want to testify can come up.
Okay.
It makes it go faster.
Okay. Liza, I said Liza, but it's not Liza. Lisa Smith, Emily Scar, Joanne Antoine, Nashona Kess, Nikki Tyree, and then there's one virtual who's favorable too. So whenever you're ready, Delegate.
Whoops. Thank you. Once I figure out how to sit in the chair. Thank you, Chair Atterbury, Vice Chair Wilkins, and members of the Ways and Means Committee. I am Delegate Linda Foley, and I'm introducing HB 412, General Assembly Special Election to fill a vacancy in office. This bill would allow Marylanders to vote on a constitutional amendment, changing the way legislative vacancies that occur during the 4-year term of office, how those vacancies are filled. Currently, the Central Committee of the departing legislator's political party recommends candidates to the governor, who then appoints a nominee to fulfill the remainder of the departing delegate's or senator's term, whether it be 6 months, 2 years, or in some cases, a complete 4-year term. HB 412 would inject more democracy and voter engagement in the vacancy filling process. The amendment, the constitutional amendment that is, if approved by the voters, would require a delegate or senator appointed using the current process to fill a vacancy that occurs more than 2 years before the end of a legislative term, only until they stand for a special election. So that special election, however, would be held during the regular primary and general elections in the presidential election year. Vacancy appointments made more than 2 years into a legislative term would not be subject to a special election. This bill is actually a compromise. You'll hear some testifying today that they believe that special elections should be held for every General Assembly vacancy that occurs during a 4-year term. However, that approach would require large expenditures by local elections boards and would likely result in very low turnout elections that don't accurately reflect the will of the voters, in my opinion. HB 412 combines the efficiency and continuity of an appointment process with the democracy of voter input at least every 2 years during an election that's already scheduled. You may be aware that a different bill along these lines was heard in the Senate last week. From what I understand from Senate members and leaders, they've indicated that the Senate bill likely will be amended to closely resemble the process described in HB 412. The vast majority of midterm legislative vacancies around the country are filled by processes that include special elections. In all, 35 states have procedures to fill legislative vacancies that include special elections in at least some circumstances. 25 states fill vacancies in their legislatures by conducting a special election in every case. Only 15 out of 50 states, including Maryland, currently use appointments without any intervening election or say-so by the voters to fill legislative vacancies. Right now, in all, 23% of the 188-member Maryland General Assembly first acquired their seats through appointment. And full disclosure, that includes this delegate. This year, in particular, there's a groundswell of support for some type of special election process to fill legislative vacancies. Over the past 6 months, there have been numerous articles on the subject, including articles and editorials in the Washington Post, the Baltimore Banner, the Baltimore Sun, Maryland Matters, and MoCo 360. There also was a recent poll that showed that 87% of Marylanders prefer a special election to the appointment process. I also note that just last Friday, the Montgomery County delegation, which includes several members of this committee, of course, voted unanimously to support a bill that would require the same special election process in HB 412 to fill local school board vacancies. And I'm sure you're going to be hearing that bill in the future. This is the second year I have put this bill before you. Prior to my sponsorship, several delegates and senators have proposed this bill in past years. In 2022, it passed the Senate by a vote of 45-0. The history of this bill goes back decades, actually. It was first proposed in 2008 by Senator Rich Madaleno and, wait for it, then Senator Jamie Raskin, representing District 20. I have the bill right here. I looked it up. It's very interesting. Who, as we know, has continued to advocate for more democracy and voter engagement as he's continued his career upward. Obviously, this bill was Democratic enough for now Congressman Raskin, and it's Democratic enough for me. So I urge you to issue a favorable report and join me and Congressman Jamie Raskin in supporting more democracy and having the voters have some say-so over how we fill these vacancies. Thank you very much. I'm happy to answer any questions.
Nice. Again, my name is Lisa Smith. I am a member of Montgomery County Democrat Central Committee. I'm here today representing myself and not the committee. I support this bill, even though it's not perfect. I'm not a fan of appointments. I think people should have the right to select their representative. The need for this bill is evidenced when comparing the 2022 event in Virginia to our own current system. In Virginia, Delegate Ronnie Campbell tragically passed away on December 13th, 2022. A special elections was held on January 10th, 2023 to fill the seat. However, in our state, when Delegate Eric Luckett resigned December 2022, just a month after the general election, the Montgomery County Democrat Central Committee was left with the responsibility. They didn't go down the line and select whoever had the next popular vote. We were the one who selected the replacement. Under our current system, the appointment process is tainted by unchecked power bestowed on local parties. This system does not promote people with transparency. Opponent of the bill may claim that the cost of special election is a concern or that the number of population will not appear for the election time. This is not true because in Virginia, they have special election. In Delaware, they have special election, even in Mississippi, who has less resources than we do. I agree that we need something, so this bill is better than nothing, but I think the appointment process needs to cease. Thank you.
Madam Chair, for the record, my name is Emily Scar. I'm the director of Maryland PIRG, the state public interest group based in Baltimore. We have thousands of grassroots members across the state. We've been in favor of some form of special elections for a long time. I can't, certainly the time I've been in Maryland for the last 10 years, working to figure out a way that we can get back to the principles of our democracy. Being able to vote for who represents you is foundational to our democracy. And so anything we can do to move away from the appointments process, we think is worth doing. And this is a fair compromise. We've also supported the measure in the Senate to establish vote by mail special elections. You've heard all the stats. We know that what we're up against. The poll that we put out this fall found that the vast majority of Marylanders, regardless of geography, race, age, gender, support special elections. And I think it's past time for us to figure out a solution to this problem. I know it's not easy, but I'm confident our smart legislators between both chambers can figure it out. Thank you. We urge a favorable report.
Thank you, Madam Chairwoman Atterbury, Vice Chair Wilkins. Again, for the record, Nikki Tyree for the League of Women Voters of Maryland. The League has supported special elections since 1985, and we were thrilled by Senator Kagan's bill that we heard last week. However, we are fully capable of recognizing that while Senator Kagan's bill would be excellent for Maryland, Delegate Foley's bill is a more practical approach to this bill, especially if you couple it with Delegate Blavacich Carr's Central Committee bill. The reality is that voters need to not only be enfranchised, they need to feel enfranchised. And the growing concern of being apathetic or completely cut out of the democratic process is concerning to the League. Special elections would start to ease that feeling. So we do urge a favorable report. Thank you.
I'm sorry, I have a sore throat if I sound weird. So good afternoon, Chair Atterbury, Vice Chair Wilkins, and members of the committee. For the record, my name is Joanne Antoine, Executive Director of Common Cause Maryland, testifying in support of House Bill 412. I know it's been a long day, so I'm not going to give really long comments. I second everything that all of my colleagues have said. I know Common Cause, long before I came on staff, has been spent a great deal of time working on this. I know that we worked with both chambers to figure out a compromise. So my request of the committee is that if we don't, my hope is that we'll move forward with a favorable report, but if not, I think knowing what the committee is willing to explore would be helpful. The Senate went further with a different model. I know that might not work here. So I think just being able to get some feedback, even if it's an election subcommittee, so that we could come back with a more viable bill that you all will be willing to consider. I think the only, at least for Common Cause, the only thing we unfortunately won't be able to support would be allowing for fundraising during the legislative session. I know that idea has been thrown out a few times, and I understand the concern, but I think this is where, unfortunately, there needs to be a strategic decision on that individual's end, whether or not you want to run on incumbency or, someone who's serving, you go out and talk to voters and, make the case for yourself. So, I urge a favorable report, but again, more than anything, it'd be helpful if we get some feedback. I think Marylanders have been letting us know over and over again that they want something to happen. Thank you.
We have a couple questions, but before that, I just want to get all the favorables out. Is Nashona Kess or Nikki Tyree here?
Nikki's here.
Oh, I'm sorry.
Nishona's not here.
She's not here. Ms. Kess? Okay, can we do the last person to testify virtually? Are they here? Okay. Okay, whenever you're ready for 2 minutes, please.
Hello, my name is Quinn Yeargain. I'm a state constitutional law professor at the Widener University Commonwealth Law School. I've also written extensively on the subject of state legislative vacancies, both in Maryland and around the country. It's obvious that Maryland's system has flaws, and the provisions in HB 412 would bring Maryland into step with virtually every other state in the country. But I want to emphasize, one of the reasons that I support HB 412 is because it preserves the core of Maryland's same-party appointment system. I want to emphasize that I would disagree with a lot of the commentary that is supportive of special elections because same-party appointment systems are more democratically legitimate than special elections are. And if special elections are to be used, it should be in the exact process that is proposed by HB 412. The reason for this is that special elections cause, in many states, a significant gap in representation between a vacancy occurring and the vacancy being filled. It's possible to speed that up in some circumstances, but it's not uncommon around the country for voters in a particular district to go months or sometimes an entire legislative session without representation. It's a significant problem. The other problem has already been flagged by Delegate Foley, that when you have special elections that occur outside of the normal schedule on a seemingly random Tuesday, not in November, in an odd-numbered year, you can have extraordinarily low turnout, below 20%, below 10%. In any event, it produces an electorate that is not representative of the district as a whole. This can cause a pretty significant problem. Where one party is more motivated than another, they can produce an outcome that is out of step with what the district would otherwise do in a higher turnout election. This is deeply problematic because that results in something worse than non-representation for voters, misrepresentation. Look, the truth of the matter is, when voters pick a member to serve in the legislature, they're picking two things. They're picking the legislator, and they're picking the party. When somebody leaves, we can't give them that same legislator, but we can give them the party. Subject to the reasonable modifications made by HB 412, I would strongly urge a favorable report in a way that brings Maryland's system into compliance with what the rest of the country does. Thank you.
Thank you very much. We do have a few questions, so we're going to start with Madam Vice Chair.
Thank you so much, Madam Chair, and thank you, Delegate Foley, for bringing this bill. Excellent presentations by everyone. I just wanted to talk a little bit about how the bill would work in practice so that we can all ground ourselves and make sure I fully understand how this would work. In terms of the appointment process, so I think that there's oftentimes a slight difference between a House member and the Central Committee appointments, where usually it's a member of the public, potentially someone who hasn't served in office before. And a lot of times with the Senate appointments, often it is a member of the House who is appointed to the Senate. So under this bill, if a member is appointed to the Senate, would a member of the House, and that senator is appointed, they are recommended by the governor, they are sworn in, that senator is serving as an appointee. Is there anything preventing a House member from running on the ballot in the primary? So let's say May 14th coming up. Is there anything preventing a House member from running as well? And would they have to give up their seat?
You're talking about in the special election?
In the special election.
Yes. The answer is no, but I would point out that that's also the case if the appointment were made in the third year of the term or closer to the next general election, that could happen as well. So the answer is that yes, a House member or anyone could run in the election, in the special election.
I'm helping you out, Delegate. I think that's something in support of your bill. I think that's a good thing. Also, just further understanding how this bill would work. We currently at this time, if this were in place, given the large number of appointments last year, because my understanding of this bill, it's basically most of the people who are appointed in the first year of a term, right? So we would have maybe close to 10 or so. I don't know the exact number. Maybe you know of how many were appointed last year. We would have maybe 8
to 10 people running on the ballot right now in May.
Yeah, yes, I think that's accurate. Yes.
Okay. And so for those who were appointed more recently, because it's 55 days, so I think that we're looking at a pre-November appointment. So I think that the timeline of when someone is appointed, I think we have to look at as election policy, we want to look at the fairness for all of the candidates as well. And so for those that are appointed maybe in early November before the bill, right before the bill kicks in, they would be newly sworn in, going into session, and then it sounds like there's some opposition to having an exception for them being able to fundraise. So are there thoughts on how we'd have an equal playing field regardless of the timeline of when someone is appointed?
An equal playing field in terms of fundraising? Is that
fundraising, campaigning, just being able to compete for someone to step up to want to serve and step into that role? And I do understand the comments about Central Committee picking people that they know, but a lot of times those are the people that are more engaged and active, and that's why they're known to the Central Committee. So for those people that do want to step up and run, but it's in November and session starts in January and they can't fundraise and compete, do we just not want them to step up and serve in that way? Or how can we, under your bill, just even the playing field so that those individuals have an opportunity to be able to run fairly as well?
Well, let me say that, first of all, I have a lot of sympathy for that because that actually happened to me. So I was appointed in December of the final year of a term, the beginning of December. The final session started in January. It was a weird session too, because we were still in COVID, so it was really weird. But the final session of the term began in January. And so I had to raise money, and it was really difficult for me to do that. In terms of leveling the playing field, I think that I personally, I mean, it's up to the committee to decide what to do here, but yeah, I personally wouldn't have any problem with pushing that timeline back a little bit if that makes it better. Someone on the panel here mentioned that they were not in favor of suspending the prohibition on fundraising during the session. You know, personally, again, that's up to the committee. I don't know the constitutionality of that. I don't know. I know that idea was floated in the Senate. I don't know how receptive they are to that. But all that being said, I just think that something has to happen here. So I'm willing, you know, as the sponsor of the bill, to consider any ideas along those lines. I would also say that I do think that the playing field isn't level when you have an incumbent with a record running in an election against people who come and file. So again, I go to my own experience because that's all I can really speak to in this area, but I think it's instructive. So when I ran in how long ago was that? 2022, seems longer than that. And I had been appointed at the end of 2021. I definitely had an advantage going into the 2022 election because I was an incumbent and I had a record. So I could point to bills that I had introduced. Someone coming off the street, so to speak, or, you know, coming up and deciding to run would not have that record. So I think that there are a lot of different things to weigh there, but I certainly, I mean, and you and I have talked about this, I certainly am open to, you know, trying to, you know, help make that more fair.
Thank you so much, Delia.
Thank you.
I appreciate your work on this.
Thank you.
I think this is not a question, it's just a comment. I think having a record, I mean, it could help or hurt, right? So it depends.
True, that's very true.
Delegate Hornberger.
Thank you, Madam Chair, and I've supported this bill and some of the other versions of it in previous years. Appreciate you bringing it forward. Two questions. One, to clarify, this wouldn't impact judiciary appointment partisan elections. They're not included in this bill.
That's correct, Delegate. The only offices that are included in this bill are delegates and senators.
Okay,
that's it.
And then the second question is in reference to the window after the presidential primary. If,
Before.
after is what I'm asking about.
Oh, I'm sorry.
Yep. And this might be a question for our council. If you decline your party affiliation or register as unaffiliated and then step down, would it just run out the clock and the governor pick? Could you show us or talk to us how that would look?
So if I understand the question, just tell me if I've got what you're saying. So what you're saying is someone gets an appointment.
No.
No.
Someone steps down from their seat
Someone steps down from their seat.
after the window of time, the first 2 years.
I got it. So
And
they're only
prior-
going to be it's only going to be an appointment then at that point. Yes.
Yep.
Okay.
And they step down, and before they step down, they register as unaffiliated.
I don't know the answer to that. I would have to defer to council on that because I don't know what the
I
answer to
believe you
that
just
is.
run out the clock and the governor makes a pick.
So what's binding on the governor is what the previous office holder's party affiliation was at the time they were last elected or appointed. So whatever their affiliation was at that time, that's what the governor would be obligated to appoint an individual of the same party. Does that answer your question?
I believe so. Thank you.
Delegate Eversole.
Thank you very much, Madam Chair, and thank you for presentation. I understand where you're going here. I have a couple logistic questions, if you will. First of all, let's start off with this one. So it's 55 days before and someone leaves. That's about, if we were going this year, February 15th is the filing deadline, or February 9th, somewhere in there. So go back to about the middle of December or so, is when they would have to have, that's 55 days before the filing deadline. So anybody who resigned before, say, let's say December 1st, would be someone that would be a position that would fall under the purview of this bill. So then if you look, the same rules are intact. We have 30 days for the central committee to pick and 15 days, and then that's a total of 45. And then it could be 15 days more if they don't pick somebody for the governor. So that's that's almost in the time period. So we're starting to get some overlap here. My first question is, as soon as the person resigns, does it open up for people to file? The minute that happens, will the State Board of Elections open up filing for this position?
Delegate, I can't speak for the Board of Elections, but the bill does say that as soon as the vacancy occurs, the governor will declare that there will be a special election.
Okay.
So I would think, and I don't want to speak for the Board of Elections, but I would think that would open it up for people to file.
Will there be any sort of public announcement so that people can be able to?
Yes, the bill does indicate that
Good.
yeah.
Okay, thank you. Then I'm proud to say I got elected the first time. But when I was elected in November, but I waited until January to be sworn in. Would these people also wait until January to be sworn in, or would they be sworn in immediately into the position?
They would not be sworn in. Well, they would already be holding the position if they were appointed, right?
No, but if someone else wins the election.
If someone else wins the election, they would be essentially a lame duck and would serve out the remainder of until the next legislative session when they would be sworn in. Yeah.
The new person would not.
Yeah.
Like I did when I was elected.
Oh yeah, I see what you're saying.
I had to wait.
Truthfully, I don't know the answer to that. I can make assumptions, but I don't want to be wrong.
Okay. Thanks. And just to be clear, this could be, and this is relevant to the gentleman who's on the screen here. We would invoke a primary for both parties or for any party that qualified. And so the party of this seat could actually change due to this election, because both parties would have a primary, and ostensibly the people from those parties or any other qualifying parties would run against each other. And so we could have a change in the party of the seat.
Yes, I think that's correct.
Okay, thank you.
Okay, just to Delegate Eversole's first point about the swearing in. So I guess this is just total speculation, but it would matter. So, if we're only in the second session of the whole term, the individual who's appointed completes the term, then at any point during the interim, the speaker could decide to swear that person in.
Yeah.
But if you are in the last session of the term, then that person would have to wait, be sworn in with everybody else. During the next term, I would think.
I think that's right, Madam Chair. I think, probably once the election, I don't know. I don't want to speculate. If you want my opinion, I can give you my opinion, but I'm not an election lawyer, but
And then
I think you're probably right. Yeah.
to Delegate Eversol's second point, so I'm just trying to understand. So that means you would have essentially possibly two special primaries, and then you would have the special general in the scenario he suggested.
You would have one primary, just like you were going to
Well,
have.
yeah, one primary with
One
two
primary,
parties.
but you would have,
With two
you would have it
parties.
in both, in both parties and unaffiliated and the whole, it would be just like a regular primary.
Okay, thank you.
Yeah.
Delegate Roberts.
Did I do that? Okay. Thank you, Madam Chair. So I'm going to tread lightly, being that I'm the newest appointed member to the House of
I've been there.
Delegates. And most recent, January 8th.
Welcome.
So I am not bringing an opinion one way or the other. But I did want to ask, and I'm sorry, what's your name?
Lisa.
Lisa.
Yes.
Since you're a member of the Central Committee. Under the current process, the Central Committees appoint vacant seats for the legislature. I know that prior to, or a while ago, they were also at least in Prince George's County, they were also responsible for appointing vacancies on the county council in Prince George's County. Is that for all counties?
Yeah. Montgomery County is only for, State House. I'm sorry, for Montgomery County, it's only for the, State House and Senate.
So they've never been able to appoint?
Never,
in other-
that's the only appointment process is this for Montgomery County.
Okay, so in Prince George's County, that changed. They were able to, and that changed. And I'm trying to figure out, I just want to make sure that I'm saying this in a diplomatic way. If the process changes, what are the other responsibilities of the Central Committee?
I am so happy you asked that
Okay,
question.
thank you. Okay, thank you.
The Central Committee, I mean, first of all, we're responsible for recruiting, in this case, since I'm a Democrat, Democrats to participate in the election, to actively get involved in the community, to get out the vote, to raise money for the party. That's our main purpose. All this other stuff is just, given to us to pacify us, to be honest with you. And I know that may not come off nice, but we're responsible for getting people to basically participate in our party, the Democrat Party. And I'm sure the same thing applies to Republicans as well. Come election time, you want people to be at the polls. So we're responsible to get volunteers to actively get involved.
Mm-hmm.
We haven't been doing that recently. I can't speak for any other county. I can speak to Montgomery County because, we have very few people showing up at the polls, volunteering.
Okay, and thank you for that perspective, because I really just want to know the perspectives of all sides, because I haven't even had a conversation about this particular process with the Central Committee in Prince George's County. But I will say that I have heard opinions that since you are elected, you are speaking for the people because the people elected you. So in a sense, they are making the decision because they put that trust into your body. And again, I'm not saying I'm for or against, just to be clear. Do you have a response to that?
Well, they elected me to enrich the Democrat Party, not to become a delegate. They, to be honest with you. That's what I'm there for, to get volunteers, to raise money, to support the party 24/7, not to, be in an upper level position.
Okay, okay, and then if I may, Madam Chair, I said thank you, Madam Chair, when I first started, right? I just wanna make sure. For the young lady, forgive me if I don't know your name, but the young lady representing Common Cause, I think I want to direct this question to you. You said that you would be opposed to, if the process changes, that you're not for fundraising during the 90-day session. I can also, just so you know, in Prince George's County, for the county council, they can raise, there's a rule where you cannot raise money or receive contributions from, say, developers. But that's only if you're not in the elected seat. Would you be amenable to, if a person has never held office? Because what you say is that it's the responsibility of that person to go door to door. I go door to door. I have run for office before, and I go door to door, and I still need to raise money because I need to leave literature for those people that aren't home when I am knocking on those doors. So would you be amenable to, just for someone who has not held office, as opposed to someone who holds an office now?
Yes. So I'd say first, obviously, the committee, the legislature can move forward with any, structure of the bill however they want. Our position, unfortunately, just won't remain the same. Our position will remain the same, right? When you look at Prince George's County Council, even if the individuals appointed, they are year-round. They are working year-round.
Yes.
And they're able to make, they're able to make decisions and vote year-round. The legislature meets for 90 days, and there's a ton of work happening during that period. And unfortunately, while I understand what you're saying too, and I know that the individual is to some extent at a disadvantage if they are here, but they are also at an advantage because they're running as an incumbent. So I think for us, it's more that when you all are in Annapolis, you are focused on the work in Annapolis, and that's it alone, right? If you are fundraising during that time, hopefully, again, you're a new person who's just got an appointment. So let's say in your scenario, you are a first-time candidate, you're someone who is just serving for the first time. It's safe to assume then that you might not have staff to actually run your campaign for you during the 90 days while you're serving, right? Unless you've got some great volunteers. So I think it's just thinking through the scenarios of someone coming in through an appointment, learning. There is a learning curve when you're coming here, trying to figure out what bills you're going to introduce, keeping up with the pace of the 90 days and fundraising at the same time. It is not in the benefit of the individual voter. So,
okay.
Yeah.
So, and I'm sorry, I guess maybe I misunderstood what you were saying, because I was thinking that you were saying that they can't fundraise in the special election. Was that not what I was saying? That's not what you were saying. Okay. So they're not already in the seat.
And
they're running, if they're running for a special election, that might end up going into the session, they can raise money?
They can up until the deadline where you all are no longer.
You cannot raise money during session.
Yeah, so not the 90, but I will add again, we've mentioned this before, right? The individual's able to raise money outside of the legislative session. The legislature, we brought public financing bills before the legislature, right? An individual who, again, maybe is at a disadvantage, they're only able to bring in small dollars, they can qualify in that little bit of time and have enough money to run a robust race, right? We haven't taken action on those bills, but I think that is one thing to consider. That is one thing to consider. And again, just lifting up that someone who is an incumbent, either way, is at an advantage because you get to run as delegate, so-and-so who is seeking appointment, who is seeking a re-election. And most voters don't vote. I shouldn't say that, but most
We're going to
voters
move
might
on to
not.
the next question.
Sorry.
Thank you, Madam Chair.
Delegate Miracuno.
Madam Chair, if I could, I love my sister over here, Ms. Smith, but I think she misspoke. The Central Committee in Montgomery County, I used to be chair of the Central Committee. The Central Committee in Montgomery County does have a process to replace county council members who have a vacancy, if there's a vacancy on the county council. I just wanted to make sure that it's never happened in recent memory, but they do have a process in place to do
Okay,
that.
guys.
Thank you.
Delegate Miracle North.
Thank you, Madam Chair, and I will try to be brief. I have a couple questions, a couple subject matters. One, I wanted to just clarify like the original intent of the appointment process and trying to understand the context of why we're doing this at this time. Okay, it's a bit of the lawyer historian in me. If you don't have the information, that's fine, we can talk offline, but that's kind of where my head's at with this bill, as well as the many years of efforts that's been thrown around this afternoon about, we've been fighting this since 1985, and one of our colleagues said I've been supporting the years, just to get a sense of why now as opposed to in the years past. If you have the information now, that's great. Otherwise, we can talk offline.
Would you like me to answer that?
Yes, please. Yes.
Madam Chair. Would you like me to answer? Okay. So I think why at this time, I mean, I think it should have happened before, let me just say that, but I do think that for one thing, we did have as Vice Chair Wilkins pointed out, I believe, that we did have a lot of appointments, because we had a new governor come in at the beginning of the term, and he appointed a lot of people, he pulled a lot of people out of the legislature. So I think that what that did was, it was a drumbeat in the public of, there's a vacancy, there's an appointment, there's a vacancy, there's an appointment. And I think that that does put some impetus on it at this time. That's number one. Number two, I do think that there is special attention being paid to democracy and voter engagement. And I'll just speak for my own party, which of course is Democrats. And I think that we as Democrats have a very heightened sense about promoting democracy and promoting voter engagement at this time. This is in 2024. So I think that's also a factor. And then finally, I would just say that in terms of this legislative term, this is the year to do it, because you don't want to do a constitutional, in my opinion, it's not ideal. Let me put it that way. It's not ideal to have a constitutional amendment like this on the ballot in the same election where we're running. So this is like the interim election, and it's a good time to have a constitutional amendment like this on the ballot. So that's my opinion, Delegate, about why.
And my last question, because I think that one was answered. So I am one of those that was appointed. And when I went through the process, in light of the awakening, the drumbeat, it was suggested that, okay, people who are applying for this appointed position, go seek out voters to support you. So my question to you is, why isn't that enough? I mean, we can create all these different ways of trying to get voter participation in the process, but for instance, why isn't that particular avenue enough? And I'm going to direct that question also to another member, a constituent of mine as well, for that answer, because I know she had direct involvement with that.
Oh, I'll answer it first.
As well as anyone else, of course.
I'll scoot on over. That wasn't an easy process. Yours wasn't easy. The last ones that we had to appoint wasn't easy. Someone told me prior to running that there's always consequences in appointment, and payback is something else. And I've been dealing with payback for each person I voted for, because we don't select the person with the most letters or the most community involvement. We don't do that. We base it on, I at least based it on what's best for that community. Said before, when Virginia had a special election during that time period, we had an appointment. We didn't appoint the person who already ran and came in fourth. We decided to appoint someone who we felt, or during that time period, was a better fit. Whether that was right or wrong, who knows? But we didn't listen to the voters. And trust me, even to this day, and it's been a year now, I still get a lot of pushback from that vote. I get, even to this day, my last vote for the person who was delegate, I still get payback for that. And when I say payback for people who ran, they come after me. Friends like, why did you vote for this person? Why did you, it's not an easy process. And I would rather have the voter take the hit than me to take the hit on a weekly, monthly basis based on what I voted for. But that would be great if we can have community involvement, but we as a community, the central community, don't listen to those letters. We don't even, some of them don't even read those letters that come in from the voters. We don't. I do, but a lot of them don't, and they make their selection based on who they like at the time.
Thank you.
Delegate Henson.
Say hi, Shanika. I am curious about the diversity and the opportunities to have to have the General Assembly or anybody look more representative of the electorate that they represent. And what appointments, what role that plays, if that plays a role. Do you all have any information, data, even think pieces that I could take a look at that says what happens? I know anecdotally, a lot of great people who went on to serve are people who are sometimes the first Black person, first, person of whatever, element of diversity that they add to the complexity of the General Assembly. But I would be interested in knowing how appointments versus special elections, how the diversity is impacted by that process.
If I could, I think that's an incredibly important consideration. And it's something that I've thought a lot about and looked into. I would just point to you, and I did some research last year on it, but that's not really current. But there in the articles that I submitted as part of my testimony in the MoCo 360 articles, I think there is some data on that in there. Kind of have to read between the lines a little bit. There's some other stuff in there that's not so good, but there is some data in there on that that you might want to take a look at. And let me just say that, whatever we did in the area of diversity, I think we've done a pretty good job. We have a really diverse legislature. We have the largest Black caucus in the country. I'm proud to say we have a large Latino caucus. We have an African-American speaker. So I think, I think whatever we've done in that area, we've done a pretty good job. And I haven't been working on it that long. People in this room have been working on it a lot longer than I've been working on it. But one of the reasons that I like the way this bill is because it preserves the appointment process. So it does allow for that to happen. And it does put that person in a position of incumbency going into the election. So that's what I recommend that you look at. I think I submitted that as part of my written testimony. You can take a look at it.
Thanks for including that.
Sure.
I'll look forward to
Thank
taking a
you.
look.
Thank
you, Madam Chair.
Okay, seeing no more questions, thank you. That concludes the testimony
Thank
on House
you.
Bill 412. The final bill of the day, House Bill 373. Delegate Vogel. And I have Carly Pugh and Nanya Obioa, Mr. Franco, Danielle Weiheimer. Oh, he has 10. And is Nashona Kess, I don't believe is here. So the rest are virtual. Whenever you're ready.
Thank you, Madam Chair, and hello, committee. I feel really bad to do this, but I unfortunately need to run out right after my testimony. But I promise I will get more chocolate covered pretzels for the kitchen as an apology. And just as they are fully qualified to be able to vote in Student Board of Ed elections, these great supporters of this bill here are able to answer your questions as well, if you have any. HB 373 is an enabling piece of legislation for counties to allow 16, 17-year-olds to vote in Board of Ed elections. To me, this makes sense. As a student, you are directly impacted by the decisions made by your Board of Education, and you should therefore have a say in who sits on your Board of Education. And I have a fantastic group of folks here who know to keep it short, who can share why this is so important. With that, thank you, Madam Chair, and I urge a favorable review.
Dear Chair,
On your
Vice
and I have
Vice Chair, and members of Ways and Ways and Means. My name is I'm not, and I currently serve as regional director of voters of to Maryland. Keeping it short, students are the biggest stake holders of the Board of Ed. As 16 and 17 year olds are on the brink of college. Decisions made in the Board of Ed die directly in impacts them, such as things as book bans, budgets, and imposed classes that could possibly make or break their future college major. Fourth, I urge you to vote in favor of this bill.
So my name is Danielle Viemeyer. I am a high school senior in Howard County, and I am a member of Voters of Tomorrow, an organization that focuses on getting young people involved in politics. I'm here today to show my support for the HB 373 bill. 16 and 17-year-olds should have a say in what happens in their community, especially in the election of school board members. Due to their influence on the curriculum and the content allowed in schools, the election of these members greatly impacts students. In Carroll County, for example, there are many books that have been temporarily or permanently removed from school libraries because they have been or are being challenged by parents. In fact, as a result of this pressure from parents, last month, the Carroll County Board of Education banned all books that have been deemed sexually explicit, but left the definition of sexually explicit extremely vague. A disproportionate amount of these books that have been challenged on account of having sexual content have been written by queer authors or authors of color, two groups that many students feel represented by, but are often underrepresented in education. This shows that students are being affected by the choices of board members that they had no control in electing and who don't represent their interests. If counties choose to lower the voting age, students would finally be given a voice in who is making decisions for their education. Studies on Tacoma Park, which lowered the voting age to 16 in 2013, have shown that students are likely to use their right to vote and that lowering the voting age increases overall voter turnout. With this in mind, this bill would give counties the opportunity to expand the voting age and increase overall voter participation and representation in politics, especially for young people. Thank you for your time.
Good afternoon, Madam Chair, Madam Vice Chair, committee members. My name is Carly Pugh, and I too represent Howard County Chapter Voters of Tomorrow, a political activist organization that aims to increase civic engagement amongst youth. I'd like to talk about some of the proposed budget cuts throughout public schools in the state of Maryland and how House Bill 373 will help to change these proposals and affect similar measures going forward. This month, Howard County has witnessed proposals for extensive budget cuts, including a reduction of $46.6 million and has targeted central office positions, as well as academic programs and services that will ultimately eliminate 348 funded positions. This proposal will increase class sizes of already packed classrooms, cut $2.2 million in funding for behavioral support and health services, $4.2 million in special education programs, $1.3 million in elementary gifted and talented programs, and will completely cut curriculum extension seminars, CEUs, which are not only important in exposure to academic rigor at that level of education, but have also played a titular role in my own educational background. This is how we prepare for high school, for the AP track, for the future tracks of higher education. And that is why Maryland's rankings are so high. They're high because we've had programs like these for years that have actually challenged kids. And if we allow other people to sacrifice them, then our numbers will reflect that. This is not just a Howard County specific issue. Cecil County School Board has made similar drastic proposals, cutting student AP exams, CTE certification exams, early college academy, outdoor education field trips, drug education, JV athletics, jumpstart programs, after-school activities, gifted and talented programs, and 113 teacher positions. These are not all of the budget cuts that are being proposed, yet these cuts directly impact students and derail us from our educational tracks. Us students are owed a greater voice, point blank. With the opportunity to actively participate in the political process by voting for Board of Education members who actually have to deal with and potentially implement these realities, we can change the outcomes that affect us from our education and beyond. And with that, I urge a favorable report. Thank you.
Good evening. Good evening, Madam Chair, Madam Vice Chair. My name is Ari Franco. I'm the Youth Engagement Organizer with Common Cause, representing Common Cause's support for House Bill 373. Across the country, education is facing a myriad of issues, and the people most impacted by these issues have not been given a seat at the table. From curriculum changes all the way to school safety concerns, young people are having decisions made for them by boards that they don't select. Giving 16-year-olds the right to vote for the school board will allow them to have a board that truly represents their interests. At Common Cause, we believe that civic engagement begins before the age of 18 and during the earlier stages of life and must be cultivated to ensure a representative democracy. Students who attend public high schools begin learning about civics in grades 9 and 10, and giving these students the opportunity to vote as early as 16, in turn, gives them the experiential learning of putting their civic engagement knowledge into practice. With the experience of voting as young as 16, by the time these students are able to vote at a state and federal level at 18, they will have already formed the habit of this level of engagement with their community. Common Cause supported the lowering of the voting age from 21 to 18 in 1971, which was an important step for our democracy in our country. Now, in 2024, Common Cause remains committed to the empowerment of the next generation of leaders and uplifting the voices of students in their school board elections. It's an important step in this cause. In its implementation, it's also important to note that if passed, the Maryland General Assembly, Maryland Boards of Elections, and school boards should be making an investment into public outreach to ensure young voters are notified of their right to vote. If the concern is that 16-year-olds will not be likely to go out and vote, we need to be giving them equitable resources to understand how to register to vote and cast their ballot. Again, this means working with Maryland Public Schools and local boards of elections. Common Cause urges a favorable vote on House Bill 373. Thank you.
Thank you. We have some folks that are here virtually. So I think 4. You can just, Louisa, whoever you see. Okay. Emily Lau for 2 minutes, please.
Good evening, Chair Atterbury and members of the Ways and Means Committee. My name is Emily Liu, and I am a senior at Wooten High School. Today, I am advocating in support of House Bill 373, which enables counties to lower their voting age to 16 in Board of Education elections. For the past 2 summers, I've worked on various political campaigns as a 16 and 17-year-old. Although I was able to serve on various political campaigns, there was one thing I wasn't able to do: vote. This was disempowering and made me feel as though my voice didn't matter. However, House Bill 373 is the first step towards changing that. Each county's Board of Education makes decisions on matters that directly affect young people, from our school curriculum to our school system's budget. I believe in education as a great equalizer, and 16 and 17-year-olds should be able to vote for those who will make decisions about the kind of education they receive, as it has the power to change the trajectory of the rest of their lives. Empowering young people to vote can also build a lifetime of civic engagement habits, as many students will have already taken a government class by the time they turn 16. Giving them the ability to vote will allow them to directly apply what they've learned in class, especially while the information is still fresh in their minds. Research has shown that by voting in the first election that they are eligible for, 16 and 17-year-olds are more likely to continue voting consistently throughout the rest of their lives. And it is clear from cities like Tacoma Park, Maryland, where 16 and 17-year-olds voted at twice the rate of voters ages 18 and up, that lowering the voting age boosts participation in elections. I urge you to support House Bill 373 to give young people a voice in their futures and strengthen civic engagement across the state of Maryland. Thank you for your time and consideration.
Okay, let's see who's next. Ms. Kim, please, for 2 minutes.
Good evening, Madam Chair and members of the committee. My name is Lauren Kim, and I am a senior and the treasurer of Montgomery County Students for Change, and I'm grateful for the opportunity to testify my support of House Bill 373. I first entered the world of student advocacy as a shy 8th grader who never dreamed that she would be using her voice in one of the largest elections in Maryland. After attending my first student member of the Board of Education nominating convention as a voting delegate, I was entranced by the opportunity to vote for a candidate who will possess full voting rights on the Board of Education. This election was my very first step into a world of elections and policy work. The chance to be a delegate and have my vote in an election was my window into my civic engagement habits at just 13. Since 2018, the voter registration for young voters has increased by 6%, which demonstrates that the new generation possesses the necessary civic knowledge, skills, and ability to vote in elections that directly affect them. Teens are also dealing with politics daily through getting familiarized with the regulations and policies in their education system, such as infrastructure and school safety, and should have a say in them. Maryland's own Tacoma Park lowered the voting age for local elections, and voting turnout increased drastically. Lowering the voting age will increase voter turnout and create a culture and habit of civic engagement for young adults, just as the small nominating convention had done for me 5 years ago. House Bill 373 moves to protect the civic rights of young Marylanders and ensure our voices are equally valued in the legislative process. So I urge you to vote in favor of House Bill 373. Thank you for your time.
Thank you. We'll see who's next. Okay, for 2 minutes, please.
Good evening, Madam Chair and members of the committee. My name is Pavani Derakala, and I'm testifying in support of House Bill 373. I'm 17 years old and a senior at Winston Churchill High School in Montgomery County, and I also serve as the president of Voters of Tomorrow's Maryland chapter. I still remember the first time I went to the polls with my parents. Proudly sporting an I voted sticker, I couldn't wait to be old enough to vote myself. Now, with a few months before I finally reached this milestone, it's become clear to me that we should not have to wait this long to take part in America's most fundamentally democratic process. Maryland has long been a trailblazer in making civic participation more accessible. In 2013, Tacoma Park became the first state in the country to lower the voting age to 16, and several others have since followed. In the first election following this change, 16 and 17-year-olds had a higher voter turnout rate than any other demographic. The success of this initiative evidences why Voters of Tomorrow Maryland believes in the capacity of House Bill 373 to expand this progress across the state of Maryland. Studies have shown that people are more likely to vote throughout their lifetime if they start at a young age, so allowing 16 and 17-year-olds to vote in county elections is an investment in our state's future. This also creates a trickle-up effect in which parents may be more likely to vote if they see their children excited about voting, improving voter turnout across generations. Young people in Maryland have knocked doors, staffed elections, and grassroots organized, all in the name of getting out the vote. As a student who's been involved in political activism since beginning high school, working with civically passionate young Marylanders to improve voter turnout through Voters of Tomorrow has made it abundantly clear to me that we as young people are qualified to vote in an educated and thoughtful manner. Moreover, allowing 16 and 17-year-olds to vote in Board of Education elections would allow thousands of students to have a voice in improving their school systems. Students are the people spending 8 hours every single day in school, so we can provide a first-hand perspective on what the Board of Education needs to be prioritizing, making our votes indispensable in these elections. On behalf of Voters of Tomorrow Maryland, and as a passionate student myself, I implore the House Ways and Means Committee to do your part to make civic engagement accessible to youth and to act in the best interest of Maryland's future with a favorable review of House Bill 373. Thank you for your time.
Thank you. And we have one more signed up to testify.
Good afternoon, Madam Chair, Vice Chair, and members of the Ways and Means Committee. My name is Alex Hossenkale, and I'm the current Legislative Chair for the Maryland Youth Advisory Council. As my peers have wonderfully demonstrated, students are affected by the choices made by their Board of Education every day, from transportation and funding to course requirements and curriculum. We, the students, are the stakeholders best equipped to articulate problems facing our school systems. The case against teen voting is built on a few inaccurate assumptions. 1, teens lack the knowledge to make an informed vote, and 2, teens are apathetic towards elections. But as it turns out, youth aren't unaware of how government works, with one analysis finding that those under 18 actually scored higher than those age 18 to 80 on civic questions. Secondly, young people do turn out in elections. It's important to note that although you've already heard much about Tacoma Park, Chevy Chase, and Rockville charter amendments, the difference in turnout among 16 to 17-year-olds is staggering. House Bill 373 balances the autonomy of counties and the rights of Marylanders to participate directly in the democratic process. The Council has voted in favor of endorsing House Bill 373 as it aligns with our platform supporting youth involvement in legislation and opportunities for youth to be part of community and statewide decisions. House Bill 373 moves to protect the civic rights of young Marylanders. As demonstrated by bodies like the Maryland Youth Advisory Council, young people are not, in fact, apathetic to the decisions made by our adult leaders and have adequate knowledge of their political surroundings. By allowing 16 to 17-year-olds to vote in the Board of Education elections, the Maryland General Assembly has the opportunity to share the focus with younger constituents, a demographic which has long been ignored simply on the basis of age. For these reasons, the Council supports House Bill 373 and respectfully requests a favorable report from the committee. We thank you for your time and consideration of our position.
Thank you, and I believe that's all that was in the waiting room. So if there are any questions, first I want to thank you all for being here. I know it took time away from school and the like, and you waited. This is the last bill of the day, because what we do is we put those with the most folks coming in to testify last. So thank you for that. Second, I am just super proud to be from Howard County with all of you representing here today. And I'm, very aware of all the budget cuts. And, they're trying to cut the BSAP summer program and a lot of really other important things. We have already got overcrowded classrooms. I've got a kid in public school there. So I'm just very proud that you all are paying attention to this and working to do something about it. So thank you for that. And also as another random side note, so we hear election law and some other bills today, revenues. Tomorrow, if you ever just have time on a Wednesday and you want to hear education bills, you can tune in, and that's when we hear all of our education bills. So yes, our education subcommittee chair. So with that, I do see Delegate Patterson has a question.
Thank you, Madam Chair, and thank you, students, for coming forward. Full disclosure, I served on the school board for 12 years, and I'm really excited to know that you're so engaged with the process of citizenship and service. The question I have has to do with House Bill 373. Several years ago, I believe most schools have student representatives on the board. How are there some concerns about this representation and the issues that you want addressed versus the need to incorporate having full voting for all school board members? I just want one response from the young man that's in front of me. Thank you.
I would direct that question to one of the other members of the panel, as I'm representing Common Causes National.
Whoever feels
I can definitely answer that for you. So one of the biggest concerns that we have, at least, and this is definitely being addressed in another bill that's coming up. I'm sure you're familiar with the student member, the board voting rights bill that's happening. However, oftentimes we see in counties that the voting rights afforded to members are not equal, in the sense that, they're not often able to attend executive meetings, vote on matters pertaining to budget and etc. Essentially what this does is it opens it up to, allowing students to have actual full voting representation in their boards of education. That's just going back to the limitations that we see in some counties in terms of that student member, the board restriction. So I hope that answers some of your questions.
It does, thank you.
Delegate Hornberger.
But I'll direct it to the young people that are here today. First off, thanks for coming out. In terms of the voting amongst your population, if you're given the franchise here, these are nonpartisan races. However, it's very easy to find the party affiliation of someone, even though it's a nonpartisan race. And do you feel that that might, because you all communicate a lot better than we do, be it social media, do you think that that sort of information would impact the way that you or your peers vote in said election?
I think that.
Sure, and anyone can answer.
I would personally say no, as as you noted, Board of Ed is mainly non-partisan, and then students can make up their own minds, which kind of in that realm as well. Dating back to a research study, I think made into 2015, talking about per parents and for months. It was found that teens voting in elections such as these didn't always follow their parents' view. So I would imply that same logic to peers.
No, excellent answer. Anybody else chime in too if you'd like. That's a great answer. Thanks.
Yeah, just briefly, to wrap that up, I think that while political identity definitely does play a role in certain situations, in terms of this specific example, students are oftentimes voting on the basis of what's affecting them specifically, and if that effect is a negative situation. Oftentimes schools aren't entirely a place for politics unless you're taking some sort of government class. And so, again, the decisions that boards of education are making directly do affect those students. And, providing this voice really allows them to open up those changes from what they're seeing from a personal perspective. So while I do believe that, political identity can play an important role in this, I don't think that in this situation, it's the heaviest role per se.
Thank you.
Okay, seeing no further questions, thank you very much. And that concludes the hearing on House Bill 373. Subcommittee members, backroom folks, we will take a 5-minute break and try to knock what we have to do out. Thanks.